All persons having business before the Honorable Associate Judges now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. We have three cases on this morning's calendar, and we'll take them in the order in which they are presented. The first case is Carlos Johnson versus United States. Counsel, you may proceed.
Yes, I am. Thank you, Your Honor. Good morning, Your Honors. Deborah Persico on behalf of the appellant Carlos Johnson. In this case, the trial court committed three reversible errors. First, it erred in admitting Instagram messages with no evidence of who authored those messages. Second, it erred in introducing Instagram videos where there was no evidence that the video accurately portrayed the events of that day, and even more importantly, no evidence whatsoever that the object that appellant was waving around in the music video was a real firearm, let alone that it was the firearm that the government seized on April 25th. And third, the trial court committed instructional errors. First, it erred in giving an utterly confusing response to a perfectly clear jury note, and then it improperly gave a Winters instruction. So those are the errors that appellant is complaining of in this particular case. On the videos, the jury cannot be left to determine on its own that an object is a real firearm. The prosecutor provided no evidence whatsoever that that object was a gun, was a real gun, and that, according to the prosecutor, was the same gun that was seized on April 25th. And you can just look at some...
Can I ask you why you say the jury can't be left on its own to figure that out? I would think that typically, I mean, there are plenty of firearms cases, cases like armed robbery cases or the like, where a firearm is not recovered. And a witness comes in and says to the jury, I saw something that looked to me like a gun.
Mm-hmm.
And the jury assesses the credibility of the opportunity of the witness to see the gun, and then decides whether there is sufficient reason to think the witness was correct, that whatever the witness saw was a gun. And so why is it different if there's a video? So it's like what a witness would have seen, maybe leaving aside deep fake videos and the like, but it's at least arguably what a witness would have seen there. And the jurors are kind of put in the place of the witness, and they look and they see what's happening on the video, and they look at the object that it's someone who may, or arguably is your client is holding, and they reach reasonable determinations. What's fundamentally flawed about that?
Okay, two reasons. First, in the cases that you're citing, the witnesses that describe an object describe it in detail, and that evidence is not used to prove possession of a weapon. It's used to prove that the defendant had the means to commit a particular crime, usually murder. And then they are tied up. The witness's description.
Well, you said two reasons, but let's before you go to the second, I'm not quite sure I follow your first.
Sure.
I think it seems to me that at least some of the time, the testimony like that is meant to prove that the defendant had an actual weapon. When there are armed robbery charges or things like that, it's not other crimes evidence. It's kind of on the date of the offense. A witness comes in and says the defendant came up and demanded my money and showed an object, and it was a black object, and it appeared to be a gun, and here's why it appeared to be a gun. And it's to prove not the means to commit some other crime, but actual possession of the object at issue, or carrying or related concepts.
All right. Well, you should also look at the incident that involved the so-called gun that the witness described. So in those incidents, a witness is saying, the defendant held this black object against me and demanded money from me. And then maybe later on, police find a black handgun and charge the defendant with committing armed robbery. In this case, there is no evidence that what appellant is doing in that video is something illegal. I mean, he's waving something around in a music video. In other words, the events of the video are not events describing a particular crime. So in a murder case, a witness says, I saw that guy with an object that looked like this kind of gun, and I saw him shooting that person. So the object is connected with a particular crime. In this case, the object that they see in the video, he is not using as an object in the video to commit a crime.
Why
So
is
Why
that
does
relevant?
that matter?
Go ahead.
I'm also a little bit confused. I thought we were talking about the difference between video evidence and witness testimony, and why couldn't you have, and I'm certain that we have had cases where, you know, in a constructive possession case like this one, where where the government's trying to prove up possession and prove, no, this is actually the defendant's gun, to have a witness say earlier in the day, I saw him, you know, put a dark object that was the shape and size of a gun in his pocket, right? Why wouldn't that be okay to then use as evidence that the gun that is in close proximity to the defendant later on in the day, but not on his person, is actually his gun, which seems to be what the video is doing.
Well, the jurors are not witnesses in this case. They're seeing something on a video for which the government is producing no evidence that that object is a gun. So it's different from a witness saying, I saw this. And let me just go to the next example so you can see why this is so important, that you can't let juries make this determination. So in 2014, police officers fatally shot a 12-year-old boy because they mistakenly believed that he was waving around a real gun when it turned out to be a fake gun. Trained officers were standing just a few feet away from this boy, and they couldn't tell whether that object was a real gun or a fake gun. How on earth can we expect jurors to look at a video where someone's waving something in a music video, not in a crime setting, and have the jurors determine that that thing he's holding is a real firearm?
Well, the example you're giving shows that witnesses can be wrong when they say, I believe I saw a gun. And yet we let witnesses come in, even though, and witnesses could often be mistaken about the things they testify to. And we let them come in and say, I saw a thing that looks like a gun. And they might be wrong, and that's what cross-examination is about, and that's why the jury will end up making a decision at the end of the day about what the evidence persuades them. So why do you think the authentication requirements for information presented to a jury vary if it is a video where, again, it's, you know, a juror could look at that video and say, that appears to me to be a gun, and in combination with other evidence, I'm going to find the defendant guilty. A juror might not do that, but why would we keep that evidence categorically from a juror so that the juror could look at it? I'm not catching the rationale for that just by the possibility of error.
Okay, well, the evidence that a government introduces has to be shown before they're allowed to put it before a jury, that it's authentic, that it's trustworthy and reliable, and that it's relevant. And in this situation where there is no evidence, and the cases show that the federal cases that we cited, state cases that we cited, there has to be some evidence that this is an actual firearm. Now the government—
And you think the appearance of it isn't itself evidence that it's a firearm?
No, it is not evidence that it's a real firearm. We don't know. And with all of the social media concerns that courts now have about videos and messages being manipulated.
Can I ask you, so that's a separate line of thought, and I get that idea. It could all be a fake. So that's a possible, you know, and witness testimony could all be fabricated. So there are always those risks. But imagine that in this video, the defendant had actually started disassembling the gun, and you could see that it had the kind of parts that you would normally see in a real gun. Would you think that still inadmissible because it's possible that it's a fake and nobody was there saying, well, this isn't a misleading angle, or do you think that you know, additional information would at some point be enough that a jury could consider it?
Well, here's the additional information. The government's own detective.
My question isn't really about, you know, something, you know, evidence in this case. It's about you know, imagine that with respect to the video in this case, the defendant had started disassembling it so that you could see that it, you know, it had a cylinder or a revolver, or it had, you know, took it apart. Would you say not enough or not enough?
No, I think according to the cases, there has to be, the government has to be able to say to the judge, we have a witness, you know, an expert, a police officer, or somebody who was actually in that video, who's going to come before the jurors and tell the jurors, that's what happened during that event. That video accurately portrays it, and he was holding a real gun. They have to be able to tell the judge that they at least have that amount of evidence before they stick a video in front of a jury, and then simply, which is what happened in this case, at the end of the trial, even in the beginning of the trial, the prosecutor stands up and simply says, that's a firearm. And it was the same firearm that you saw here, where there's no evidence of that.
Counsel, this is your extrinsic evidence argument, that they have to have extrinsic evidence to prove what's in the video?
According to the, yeah.
I'm still stuck though on Judge McLeese's hypothetical. I mean, what if in the video, he stops dancing, comes over to the person who is filming, loads the gun, like takes a bullet visibly, puts it in, you know, and loads the gun in full view of the video. And, you know, a bullet is not going to go into a fake gun, into a water pistol, right?
Okay.
So what if he does that? That is not enough to self-authenticate and obviate extrinsic evidence? Sorry, my question keeps sort of dribbling on, so I'm not trying to trap you into interrupting.
No, but listen to what you just said. You just said, if on the video, he puts a bullet into the gun and a bullet's not going to go into a fake gun, that is sufficient. But that's not what happened here. This is what I'm saying. You can't leave a jury to determine whether something in a video is real or fake. And the cases are now showing that for the advanced technological stage of all of this social media evidence, the government has to be able to show that whatever's in that video is an accurate portrayal and that that's a real gun. And
Ms.
my
Persico,
yes.
if I take your point that if the jury only had this video, the only evidence at trial was this video, you'd have a very good point that you could say to the jury, look, you don't know whether that is fake, whether it is staged, whether it is real, you know nothing. You cannot find, based on that video alone, that he was in possession of a gun. On the other hand, if a short period of time, except that this is a short period of time for the sake of this discussion, but if a short period of time after the video, the defendant is seen 1 foot away in his own bedroom from an object that really does match in appearance the object in that video. And it turns out that that object that he's found 1 foot away from is in fact the gun. And we have police officers come in and they bring it into the courtroom and they show the jury, and there's no dispute that it is a gun.
The gun from the video? I'm sorry, are you saying that the gun seen in the video, the police officers come in and show that that was the gun? Oh,
No.
okay.
I'm saying that shortly after the video, the police entered the defendant's bedroom and find him on the floor, and 1 foot away from him on the floor is an actual gun.
Mm-hmm.
And nobody disputes that in this case. And the actual gun that is found 1 foot away from him shortly after the video matches in appearance the object that might be fake, might be real, in the video. Now we have more information, and the jury can draw, with some degree of confidence, the inference that the object they saw in the video was not a fake gun, but was the same gun that they saw on the floor. And now they have some additional information, because to the extent there's an argument about, well, you saw it near him on the floor, but that doesn't mean he was in possession of it.
Mm-hmm.
The jury can reason, well, you're right about that if we look at that in isolation too. But when we see that he was waving it around in his own, hand on the video, we can say he was in constructive possession of it. In other words, each bit of evidence reinforces the other. And there's some more evidence in this case besides what I just mentioned. Why can't the jury reason the way I've just described?
Because the jury has to have evidence, something. There is something distinctive about this particular gun in the video. These are the markings of a 40 caliber handgun. This is the shape of a 40 caliber handgun. That's why this looks similar to what was found in the room. Now,
why don't they have that evidence here, where the prosecutor in effect says, ladies and gentlemen, look at that video. Look at this gun that we found on the floor. You decide, tell me, they both have this red laser pointer? That's sort of an interesting thing that makes them look alike. They both are black. That looks alike. They're both about the same size and shape. That looks alike. We know that's a gun of some kind in the video too, because it also has that canister shaped, I've forgotten what you call it, a magazine, but which, kind of thing that attaches to guns. I don't know why the jury, suppose, or here's another hypothetical.
Can I respond to that
one?
Okay.
That's, I think, the rationale that's employed here.
Yeah, but what you just described is a prosecutor testifying. A prosecutor can't testify, that's the gun, that's the same gun that was on the floor. And that's exactly what they did in this case. The prosecutor put on no evidence that thing that he was handling had any distinctive features of a 40 caliber gun, could have shot bullets, nothing like that. He simply stood up and told the jury, not you can see for yourself. He told the jury that is the same firearm that was that the police.
Well, that seems like a different argument, right? Like that the prosecutor overstepped his bounds in closing. But I thought we were talking about the admissibility question, and if I understand what you said earlier, to my hypothetical about loading the gun in the video, you said, okay, that would be self-authenticating, right? And so it seems to me that there's a spectrum, right? There's certainly a point at which we would allow a jury to make a decision that that's the gun, in my hypothetical where the gun is being loaded. There's certainly a point where we would keep it from the jury. I mean, if he were dancing in the video with a teddy bear in his hand, we wouldn't admit the video as evidence of constructive possession of the gun, right? Like a teddy bear doesn't look anything like a gun, right? But then there's the gray area in between of this object that is consistent with the appearance of a gun, has the laser pointer on top of it. And I'm struggling to understand why we wouldn't take that to the jury and let the jury decide. Now, it sounds like you've got this other argument that the government usurped the jury's decision-making and sort of made the decision for them, but that's not an admissibility question. And I want to stay focused on the admissibility question.
Okay, so the admissibility question, again, if you look at all of the cases that are in the appellant's initial and reply briefs, there has to be more evidence introduced than simply he owned the social media account, that's him in the video, he's waving around something black. And if you can't find that the government should not have introduced that evidence, then certainly you can find that there was prejudice in admitting it and that there was insufficient evidence that he possessed that gun on April 25th. So the cases that we've cited show that some extrinsic corroboration is needed, and one of them, especially look at the James case, the DC District Court case, it has to be shown that it's an actual firearm before it's admissible. So that's our position, that it does not get introduced because the government has not shown authenticity, that the video portrayed the events that actually happened, that it's trustworthy, and that it's even relevant because nobody knows, because they never proved that it was an actual gun.
Was there a concern articulated at trial about this deep fake question?
About
a deep fake question, right? About alteration of videos and.
Well, in the beginning, the argument was made that there was no evidence that the video portrayed the actual events. The arguments were made pre-trial, that it should not have been introduced.
Okay. Let us hear from counsel for the government, and then we'll give you a few minutes to move on.
Okay, thank you.
Thank you, Your Honors. May it please the court, my name is Ethan Carroll, and I represent the United States. To answer Judge Easterly's question, there was no concern expressed pre-trial or during trial that this was a deep fake. The question was about admissibility, and the standard for admissibility that this court has articulated is clear, and it's a reasonable probability of identity. A reasonable possibility. I'll keep coming back to that, I expect, during this argument, a reasonable possibility.
I'm sorry to cut you off right there, but I just wanted to make sure I understand that you said that the question is admissibility. Are you saying that the deep fake concern doesn't go to admissibility, or are you just saying, is your point solely this really hasn't been teed up for us here?
It hasn't been teed up. It wasn't raised below. It wasn't raised in closing argument.
That wasn't a concern. But it could be related to admissibility.
Yes, in a separate case.
I just wanted to make sure that I understood what you're saying.
Sorry for my lack of clarity. So this court has articulated the standard of a reasonable possibility. And it's also said that that is lower than the threshold for authenticity articulated in Federal Rule of Evidence 901.
How is it lower? Could you explain how it's lower?
Sure. And ultimately, Judge McLean, it doesn't actually matter for my argument that it's lower because we can sort of assume arguendo that Federal Rule of Evidence 901 standard applies. But in, I believe it was Stewart, the 2005 case, this court cited to Winfield, the sort of third-party perpetrator case, where it said that in Winfield, this court said that it disavowed a more exacting standard of relevance that was required under Federal Rule of Evidence 901. But we're assuming, for the purposes of argument, that even under Federal Rule of Evidence 901, that this evidence was admissible. Even under
all right, let's go slow. Sure. What do you understand the Rule 901 standard of?
That's where I was going. So Federal Rule of Evidence 901 requires a prima facie showing of authenticity such that a reasonable jury could conclude by a preponderance of the evidence that that this evidence is what the proponent says that it is. So it's a prima facie showing of authenticity. So that's what the court has to do, so that the jury can actually resolve whether it is what the government says it is by a preponderance of the evidence.
So under Rule 901, does the court say in determining that something is admissible, in determining the authenticity question with respect to admissibility, does the court say, okay, I find by preponderance of the evidence that this is authentic, or does the court say, I find that a reasonable jury could find by a preponderance of the evidence that this is authentic?
The latter.
And that's Rule 901. Now, how does that differ from what you call the reasonable possibility standard?
So the only sort of data point that we have for that is what this court said in Stewart and Winfield. And here it really isn't material because
it may or may not be material here. But I just want to understand the standard. When I use the words a reasonable possibility, I want to know what I'm saying if I use them.
All that we have is what this court said in Stewart, and then also what it said in Winfield, which is that.
Well, what does the United States think the judge should be saying when the judge says, all right, I'm applying the reasonable possibility standard?
I don't have our position on that beyond saying that even under Rule 901, this evidence would be admissible.
Can I ask
I'm wondering whether there's in fact any difference. I'm sorry, Judge.
I was just going to ask, do you think that it's a parallel question to the question Judge Glickman asked about how Rule 901 operates? Do you think that a judge that is applying the reasonable possibility standard is saying, I find there is a reasonable possibility, or is the judge saying, I think a reasonable juror could find a reasonable possibility?
The former. What the judge has to find is that a reasonable juror could conclude by preponderance of the evidence.
No, I'm not asking about 901. I'm asking now under the reasonable possibilities.
Okay. Sorry, I misunderstood. Sorry, if you could repeat the question, I misunderstood its premise.
So under our reasonable possibility standard, do you understand it to be a judge saying, well, I've looked at the circumstances here and I find a reasonable possibility that the object at issue is what the party who admitted it says it is, and therefore that it's relevant to the case? Or is the judge instead saying, I'm not trying to figure out myself whether there's a reasonable possibility. The issue for me is, could a reasonable juror find a reasonable possibility that this object is what the party who's seeking to admit it says it is, and therefore that it would be relevant?
I'm actually not sure. I don't think this court's cases have really, I guess, put that much sort of, have really conceptualized the standard to that
And a
degree.
related question, is it your sense that in answering whichever of those two variants of the question the trial judge should be answering, the trial court considers all of the circumstances in the case, including what other evidence there might be, other than what's immediately surrounding the object in question, but kind of some of the circumstantial evidence that Judge Glickman was referring to about what are the circumstances of the charge, of the recovery of what we know to be a gun, for example. Is it all of those circumstances that are taken into account?
It's all of those circumstances. We've cited three cases in our brief: Stewart, a 2005 case; Ruffin, a 2019 case; and Philip Johnson, a 1997 case, that are all consider whether an object is the same object that was later recovered or earlier used. And I guess sort of are examples of what a reasonable possibility requires.
And can I ask you just one more, another general question? Is it your sense that the idea is that reasonable possibility is less stringent than preponderance, and therefore that in theory, under our standard, a judge who looked at the circumstances about a particular piece of evidence that the party was trying to move in, saying it is the thing, here's the thing that it is, and therefore it's relevant, that a judge can look at that and say, well, I've considered all of the circumstances, and I think there's like a 25% chance that it is the object that the moving party says it is, and if it is that, then it would be relevant. So I'm going to let it in, because either I find there's a reasonable possibility, and therefore let the jury figure it out. Or maybe I find that a reasonable juror could find that that's a reasonable possibility, and therefore, let the jury figure it out. Is that your sense of how they're different?
It's less than a preponderance. In Robinson versus United States, a 2005 case from this court, this case made clear that a prima facie case is less than a preponderance of the evidence. And that's what's required under Rule 901.
The reason I and perhaps other judges on the panel are pressing you on this is that if reasonable possibility simply means, well, I can't say it isn't, in effect, what it purports to be. That seems problematic. Suppose the government says, on the street outside the defendant's house, we found this letter. It's handwritten. It's handwritten, or no, even better, it's typewritten. And if you just read the letter, it certainly looks like it's from the defendant. It says something like, "I, defendant John Doe, say X," in the letter. And the judge looks at the government says, "Well, look at this letter. There's a reasonable possibility that this letter was written by the defendant. We found it in the same city that the defendant lives in, or the same universe, whatever, the same world." Now, the judge, I think, would have to say, well, there's a reasonable possibility. But I have a feeling no judge would admit that without any additional evidence of its authenticity. And I'm not giving you a sort of slightly silly example, but there are many real examples that are just like that in the case law.
Of course.
I wonder in the end whether we really do mean something different by reasonable possibility when we're talking about authentication, which is only a subset of relevance. Bear that in mind. Whether we mean something more, whether we mean the judge has to be able to say that at the end of the day, taking all the circumstances into account, a reasonable jury could find it likely, that this item is what it purports to be. But you seem to be saying reasonable possibility means less than that.
So
this is what's been going through my mind.
So I am saying
unless you want to argue that letter can come in and let the jury just.
I'm not. And what I want to be very clear, we are saying that under the standard of Rule 901, that this evidence would come in. And we're saying.
Got that.
Yeah. Okay.
I understand the government says that all this is just three appellate judges worrying about abstract doctrinal.
So our entire brief proceeds on the assumption that even under Federal Rule of Evidence 901, that this evidence would come in. We are not saying that this court needs to, or in this case, explain or consider what difference there is between the reasonable possibility standard and Federal Rule of Evidence 901, because even under Federal Rule of Evidence 901, this evidence would have come in. I hope that is clear. We did make out a prima.
It could not be clearer.
Okay, we did make out a prima facie showing of authenticity, such that a reasonable jury could conclude by a preponderance of the evidence that the evidence was what the government claimed it was. The videos, unlike a witness's testimony, can be paused and looked at on a frame-by-frame basis. And if the court does that, the court can see that this is a black firearm. It can see the way in which it fits into appellant's hands, the approximate size of it. It can see when appellant actually points the gun at the screen, the size of the muzzle. That is much more than in Stewart. So that's the 2005 case that I mentioned, where there was a shooting outside of a daycare, and the victim described a gun as a shiny automatic pistol with a color like silver. And this court found that description, just a shiny automatic pistol with a color like silver, was enough to render a gun that was later found months later in a car with that wasn't even appellants, the defendants in that case, to render that gun admissible. So if a shiny automatic pistol is enough to say that a silver pistol that's found months later is the same gun, then surely a video that shows a black gun with a muzzle size that fits in with an approximate size and shape with a red laser beam on it is the same gun. We have more than Stewart. So whether it's under the reasonable possibility standard, whether it is under Federal Rule of Evidence 901, the video was sufficiently authenticated to render it admissible.
May I ask you a couple of factual questions about the record? Because some things are said in the brief, and I'm not sure what was actually argument and what was actually proven.
Okay.
5 cell phones were as I understand, were retrieved from the home during the search, execution of the search. 3 of them, I think, or maybe only 2, from the room, from the bedroom. The phone that was connected to Mr. Johnson by his phone number, and was that found in his room?
It was.
The evidence established that was found in his room?
Yes, so there were 5 different phones, 2 of which were ZTE cell phones. Those were recovered from a basket in the living room. That's on pages 302 through 303 of the August 22nd transcript. And then the other 3 phones were recovered from the bedroom. That's on page 319 of the same transcript. And when Detective Roy testified, he said that it was an iPhone that was receiving messages for the Loyal account. That's on page 269 of the same transcript. So by process of elimination, since the phone that was receiving the messages wasn't a ZTE, that means it has to have come from appellant's room.
I hate to ask this stupid question. What is a ZTD? What is a ZTD?
ZTE is a brand, so it's not an iPhone. Yeah, I don't know what it stands for. I'm sorry.
So okay, so you went to where I was going. So there's evidence, there's actual testimony that the iPhone, that one of the iPhones found in the bedroom, his bedroom, had his phone number and was receiving push alerts, or was connected in some way to the Instagram account.
Not entirely accurate. So there was evidence that one of the 3 phones recovered from his bedroom was receiving push alerts from the Loyal account. And then there was also evidence that the Loyal account, the Instagram account with the name that included Loyal in it, was linked to his phone number. But that was different evidence. There was no evidence presented at trial of like a download of the phone. It was from his resume, which had the phone number that was associated with the Loyal account through the Loyal account's business records. So it was and that was also a verified phone number, which meant that Facebook, Instagram had sent a text message to that account, and someone on the receiving end of the text message
that phone number, right?
had then responded. Yeah, so those were 2 different pieces of evidence.
Okay. Okay. Good. Got it. Thank you.
I do see that my time is up. I don't know if there are other questions on the authentication issue, or if there were other questions that this court wanted me to address. I know that there are a number in the brief, and I just want to make sure that. One
question we could ask you briefly. Was it really necessary for the government to insist on the that the jury be instructed that he had to be in possession on or about April 25th?
So I don't think it was necessary. I also don't think that it was error. It was not the answer to the question that the jury asked. So the jury asked, is the possession we are to determine exclusively limited to the time of the search warrant? The answer to that question wasn't a yes, because there was also evidence from earlier in the day before the search warrant. So there was evidence that appellant and Ms. Campbell, the woman that was in his room, went to bed sometime around 2:30 or 3 o'clock in the morning, also on April 25th. And so a jury could have found that at the point in time that appellant actually took the gun out of his pants, sometime between 2:30 or 3, and when the police knocked on his door at 6:30, that's the point in time when there was possession. It is confusing for a jury. How can someone possess something when they're asleep? So to the extent that they are saying, is the time exclusively limited to the time of the search warrant? The answer to that wasn't yes, but the government didn't have to insist on an on or about instruction, but we also think that it accurately stated the law, the allegations in the indictment, and that even if it was error, that ultimately it was harmless because that wasn't the basis for the jury's verdict.
Can I just ask a follow-up question about that? I mean, I thought that the government's theory at trial was constructive possession, not actual possession.
It was, and the entire
the scenario that you just described is an actual possession scenario.
It is, and this wasn't a question that the parties were arguing about in their closings. During closing,
but it came up in the jury note, which is why it's confusing. It seems like the answer clearly was yes. I mean, if the government's theory is constructive possession, then the time frame for constructive possession is the time when the police walk into the room and see the defendant lying next to the gun and multiple magazines, right?
Yeah, perhaps the thrust of what I was saying, I may not have been particularly clear. And what I was trying to say is that during the closing arguments, the timing of when appellant possessed the gun just wasn't what the parties were debating. It was a credibility determination about whether you believed the government's case of constructive possession on the one hand, or whether you believe that appellant's sister had come into the room and put the gun by his head so that he would feel comfortable despite not waking him up to tell him that it was there. And then
we just had arguments. How was the jury instructed on actual possession or only on constructive possession? I just don't recall.
I don't recall either. I know that when they went through the jury instructions, that both parties were clear that this was a constructive possession case. I don't know the answer to your question with certainty. I suspect just constructive possession, but I'm actually not sure. So I don't want to, please don't hold me to that.
May I ask you, before you sit down, Mr. Carroll, may I ask you another
Absolutely.
Question? We were talking a few moments ago about, even under Rule 901, say,
Yes.
That the evidence was sufficient here. So whatever the standard is, did the jury have to be, and was it instructed on making the authentication determination by whatever standard we think is appropriate? Was there a particular instruction to the jury on that? How does this work?
So I know that throughout appellant's argument, his counsel made erroneous argument about the standard at which the jury had to resolve certain facts. And then in response to that, at the close of the government's rebuttal, Judge Salerno, in his first instruction, told the jury about the threshold at which they had to find facts and the ultimate threshold of proof. I just don't know if, I don't think, there was not a specific question, or there wasn't a specific instruction about, ladies and gentlemen of the jury, you have to find that at a preponderance that the gun on February 18th, was what the government says that it was. What there was in the supplemental instruction was that the jury had to make that determination. So it's in the second paragraph of the supplemental instruction.
I do recall the jury being told that if you find that this, I can't even quote it from memory now, but if you find that this that the video showed the gun, or you may use it for the following purpose. But I'm wondering if that's the only thing that was said, or was there anything more said to the jury about
so
that determination?
The actual language which I have in front of me is that it is up to you to decide whether to accept that evidence if you find that Mr. Johnson possessed the firearm at issue in count one at an earlier time. If anything, the jury, I guess.
You think they might have thought they had to find it beyond a reasonable doubt?
Exactly. Yeah. What I think what I'm saying.
Well,
that's exactly. So I don't think there was any harm in that instruction because the most likely mistake that they would have gotten from that is that they had to find it at some level beyond preponderance.
I mean, you would agree that unless the jury believes by whatever standard is applicable, that the social media evidence is authentic and that the video is authentic and that really is a gun in the video. Unless they make all those findings, and indeed, unless they find that gun in the video is the same gun as the one, then it's all irrelevant. It should have no bearing because then it could only be used for either it's irrelevant because they're relying on fake evidence, or it's irrelevant because it's propensity evidence.
I do think that I also want to caution that I don't think that's something that is particularly open, that is easily reviewable. This court.
I ask you whether that's right. I mean, imagine that a juror looked at the dancing video and said, "I have no idea whether that's the same gun." But one thing I notice is there's definitely a red laser pointer on whatever that is, and if I'm trying to figure out whether Mr. Johnson was in constructive possession of the gun, that was found near him during the execution of the search warrant, would have a red laser pointer on it, and so I'm going to find that is the same red laser pointer, and if I know he had a red laser pointer a couple months ago, I'm gonna, that ties him more closely to the gun that was found near him, even if it's a different gun. Would that have been an impermissible chain of reasoning, or do you think that would have been a permissible chain of reasoning?
We think that would be permissible. I suppose just to follow up on Judge Glickman, in response to your question, I do think it is a difficult in terms of.
I accept Judge McLeese's emendation. That's
okay,
yeah, works, right.
and that also just informs how we see harmlessness. We don't think that it's Instagram evidence across the board. We do think that there are various categories of Instagram evidence. The message from a few days before, the videos from 2 months before, and that in reviewing harmlessness, that it is important that this court keep that in mind. I do see that my time is up. If there are no further questions, we'd ask that this court affirm the judgment of the Superior Court.
Thank you. So, Ms. Persico, would you like to take a few minutes in rebuttal?
Yes, thank you very much. First off, on the standards, the reasonable possibility standard is a relevance standard, not an authentication standard. If you look at Stewart, it says the test for relevance, it requires only a reasonable possibility of a link between the contested evidence and the crime. But in Springer talks about the authentication standard. Springer says that the government must show by clear and convincing evidence that what they're proposing is real, has to be authentic, accurate, and trustworthy. And then if you look at the Bryant case in this court, that shows clearly, they say a video is authenticated because a witness present during the shooting testified that the video accurately portrayed the events. And back to Stewart, where they talk about relevance, a reasonable possibility, it applies to relevance, not to authentication. And they're talking about a pistol that was described by a particular witness, and then an expert connected the gun that was found and the bullet that was found to the kind of gun that the witness described. So those are the standards that this court has used. And for authentication,
Ms. Persico, before you, the case you mentioned after Stewart, the one in which you said the government must show by clear and convincing evidence. I'm having trouble hearing
I'm
that
sorry.
case.
Oh, okay. Do you want me to repeat that? I
Could you
said
spell the name of the case, please? Because I'm having.
Springer, Springer, S-P-R-I-N-G-E-R.
Thank you.
Springer, sorry. And so that shows by clear and convincing evidence. And then as you get into all of the other cases, the much more recent cases that are reviewing evidence of social media messages, social media videos, the standard becomes even clearer for authentication of that particular type of information. So with respect to messages, if you look at the Brown case from the Third Circuit, and the Brown case from Arkansas, and the Smith case from Mississippi, all of those cases and others in appellant's briefs show that there were witnesses who could identify the writings in those messages as something the defendant authored by various different ways. You can, in the brief, it explains it in more detail. So our position is that the clear and convincing evidence standard, the prima facie evidence standard, the relevance standard in the, in the Stewart case, the government did not meet any of those standards in this particular case, and they're spelled out in your own cases over the years.
Let me ask you a hypothetical, if I may. Suppose you have a bank robbery. Suppose you have a bank robbery.
Okay.
And, the three bank robbers run out of the bank, and, there's sort of vague descriptions of them and so forth. And their last scene going in a certain direction. And there happens to be in an alley not far from the bank, there happens to be a surveillance camera. And the surveillance, nobody is there, it's just the camera. And the surveillance camera shows three people who they match in certain respects, maybe not the descriptions, but with this running through. And one of the persons has a black object in his hand that has a red laser pit, the red laser pointer on it, and they run through the alley. And the government wants to introduce that video to prove that this was in fact an armed robbery.
Okay,
That's
so
of the bank. And the government we have no witness who can testify that was a real gun in that video. In fact, it's up to the jury to decide whether they think that those three people in the video were even the robbers. It's a question of matching their appearance in the video to whatever it say. Is it your view that that video cannot come in without something else? I had a case assume the timing is correct.
Okay, well, I had a case similar to this where video surveillance caught someone leaving the scene of a murder very soon after the scene of the murder. And the government was required to call the people who had the video surveillance equipment to testify that that equipment was accurate, that the timing of the video was accurate. Now, they couldn't testify that what the guy in the video had was a gun or whatever, but someone came in to tell the jurors, and before it was admitted into evidence, the judge knew that the government was going to present evidence that that video accurately portrayed the events of people passing through the alleyway. We don't have anything even remotely close to that here. No one testified that what happened in that video, nobody testified about how it was recorded, when it was recorded, who may have recorded it. Someone there were a bunch of people in that music video. The government might have been able to call one of those people to come in and say, yes, I was there. That's what was going on when I was there. And Shakese Campbell, appellant's girlfriend, the government called her and couldn't even spit the word gun out of its mouth. The prosecutor asked Shakese Campbell, do you see something in that video with a red laser on it? And she answers, yes, I see something in the video. The prosecutor couldn't even ask her if it was a gun because they have no evidence that what he was holding was a gun. And look in the preliminary hearing, Detective Roy Thomas, I'm sorry, it might be Thomas Roy, testified. And the court asked the detective, when you looked at that video, can you tell if what he's holding is similar to the gun that was seized? And the detective said, I can't tell. I mean, the government didn't produce any evidence because they had zero evidence that what he was holding was a gun. And on the on or about instruction, I mean, this instruction, I can't even understand this instruction. It never should have been given. It was perfectly clear from the evidence the government presented that crime, they were alleging that crime was committed on April 25th, not on or about April 25th, not on some date reasonably near April 25th.
Well, I mean, again, if the indictment did say on or about, so if you mean what they were alleging in the charging document, they said on or about. Now, if you mean their theory at trial, that's something a little bit different.
Well, but once they got to trial, their only evidence was that it happened on April 25th, that the possession on the day when they seized the firearm.
Do you agree? I mean, part of the government's point is that the exact question from the jury was not about the date of the execution of the search warrant, but the time of the execution of the search warrant. So I guess the minute the officers walk in and maybe the period while they are executing the warrant. Do you agree that at a minimum, it would have been permissible and appropriate to tell the jury, no, it doesn't, the focus is not exclusively on the exact time period that the officers are standing in the house executing the warrant. If for some reason you had some concern about whether the defendant was in possession of the gun during those however many minutes it was, but you believe that the defendant was in possession of the gun earlier that day, that would be no grounds to acquit. Do you think that it would have been an accurate instruction or an inaccurate instruction?
Well, first of all, I don't think that's what the jury had a problem with. The jury.
Right, but my question, maybe you could make that second. Maybe you could make that second of all, but and make first of all. Do you think that would have been a correct or incorrect instruction?
To instruct the jury that they could find that he possessed it a few minutes before the police walked in. Is that your question?
Yes.
Well, yeah, but the judge should make that clear. It had to be on April 25th. So if it was a couple
of
11:30,
if it was like 11:30 a.m. on the 24th, you would have said that would have been
an
unlawful ground for conviction.
Well, then say that. The judge should have told the jury that. This is the problem here. The instruction is too confusing. If, in fact, the judge thought that that's what the jury's question was, the judge should have said that those exact words, not, well, you can find it on or about April 25th, some date near it, not an exact date, maybe, someplace near that date. Jurors can't figure these instructions out, and that's why the courts have to be especially clear when they're responding to a very clear jury note. The jury note is possession exclusively limited to the time of the search. Yes. Can possession be at any time?
I thought you acknowledged that the answer to that first question is not yes. Well, no. It's not limited to the time of the execution of the search.
No, the argument at trial was that the answer should be yes. And
I understand that, but I thought in response to questions I was asking you, that the answer to that question, strictly speaking, is not yes, but rather would be no. It's not limited to the exact time period where the warrant was being executed.
Well, I think it has to be, I mean, my position is it has to be at the time the warrant was executed, the police are there, they see the gun, did he possess it at that point? That's my position. You're saying, you know, if the jury thought, well, maybe he took it out of his pants a few minutes before the cops had, you know, arrived, that's all total speculation. And that's why I say the judge had to be clear. Yes, possession was at the time. The police seized that gun in the bedroom of the appellant. And I don't believe there was any instruction on the, oh, I'm sorry, the instruction, I think Mr. Carroll did talk about this. The instruction does reference something about the firearm, you know, that they have to find that it was the same firearm after all of this confusing stuff about on or about. And also don't forget that the judge allowed the jury to find that if they found that was the same firearm, then they could find him guilty not only for the firearm in the video, but also the ammo and the feeding device that was found in the apartment, which the government concedes was error for the judge to tell the jury that. Does the court have any other questions?
No, I think we're done.
Thank
Ms.
you.
Persico, thank you. Mr. Carroll, thank you. The case is now submitted, and the two of you may log off.
Okay, thank you.
We will call the second case on the calendar, which is 3000 7th Street versus Hazel Thomas, and it's consolidated with Hazel Thomas versus James Buckley and other appellees. Counsel, you may proceed. The second case on the calendar, which is 3000. Are we having a sound problem? Versus Hazel Thomas.
I'm here, Your Honor. Todd Lewis on behalf of Ms. Thomas.
I hear some background speaking.
It sounds like someone might have their YouTube feed going. If they could turn that off, and if the other parties who are not speaking could mute themselves, that would be helpful.
And, Your Honors, I understand that I'm going last. Is that correct?
You are Mr. Lewis. I think we are going in the order shown on the on our calendar sheet here, which would be Mr. Thompson arguing first, then Mr. Lynch, and then you. Is that not correct?
That's my understanding, Your Honor.
Then I think it would be helpful if Mr. Lewis and Mr. Lynch both muted themselves while Mr. Thompson is speaking.
So, Your Honor, may I ask one question? Are Mr. Lynch and I splitting our time? Since we were on the same side, we had planned on me speaking for 5 minutes and him speaking for 10 if we were dividing our time.
That's fine. That's acceptable to us.
Thank you.
Okay, you may proceed.
Your Honor, this is Robert Lynch. I will follow Mr. Lewis. I'm the appellee, and Mr. Lewis is the appellant for my case.
Oh, okay.
Thank you.
Okay, in your case, because they're consolidated. That's fine. So the order will be Mr. Thompson, Mr. Lewis, Mr. Lynch.
Thank you, Your Honor.
I apologize for asking again, but Mr. Lynch, if you could mute yourself, it just makes the sound better for everyone else.
Yes, Your Honor.
Okay, Mr. Thompson, you may proceed.
Thank you, Your Honor. May it please the court. My name is Brian Thompson. I am counsel for Appellant Appellee 3007th ST 222 SB LLC. This matter involves two consolidated appeals related to attorney's fees awarded to Hazel Thomas in two consolidated matters below. The 2012 case, which was a quiet title action filed by 3007th, and the 2013 case, which was a case filed by Ms. Thomas, to which 3007th was not a party. Ms. Thomas sought an award of fees against 3007th and the defendants in the 2013 case jointly in the amount of $244,600 in attorney's fees, and $3,863.88 in cost. The trial court rightfully found that the American rule barred an award of attorney's fees and costs against 3007th in the 2012 case. However, the trial court awarded attorney's fees to Ms. Thomas against 3007th for fees incurred by Ms. Thomas in an accounting proceeding before the auditor master. The court awarded those attorney's fees to Ms. Thomas solely because 3007th was the party that requested the matter be referred to the auditor master for an accounting. There is absolutely no basis in law or the facts of these cases that would permit an award of attorney's fees against 3007th. Simply put, the American rule prohibits any award of attorney's fees against 3007th, including any attorney's fees incurred in the auditor master proceeding. In assessing an award of attorney's fees, there are two standards of review at play. First, one must determine whether or not the court had the authority to enter any award of attorney's fees. The standard of review is de novo. If the court did in fact have such authority, the standard of review applied to the award of attorney's fees is abuse of discretion. In this appeal, filed by 3007th, we need go no further than the first step of the analysis regarding 3007th. Simply put, the American rule applies here to the entire case, including any fees awarded related to the auditor master proceeding. There is simply no statutory or other court rule applicable that would result in an award of attorney's fees against 3007th.
As I read the judge's order, he seems to have thought that Rule 53 provided the basis for his award of those attorney's fees.
Right, and if you look at Rule 53, I believe that it only applies to compensation to be paid to the auditor master himself or herself. It doesn't apply to any attorney's fees that would be awarded among the parties. Therefore, I believe that the American rule still applies and that court rule would be inapplicable. Both 53 or 53I would be inapplicable at that point.
Your opponent seems to argue, leaving aside Rule 53, that another possible basis upon which the trial court could have held you responsible for those amounts was sort of an agreement that that was what the process was going to be. And you've identified, I'm going to ask Mr. Lewis about exactly what discussion has in mind, but you identified, I believe, if I'm recalling correctly, a possible passage that touches on the topic. And I know your take on that is that there certainly was no agreement by your client to pay the attorney's fees for your opponent. If there was any agreement, it was about the expenses of the costs of the auditor and paying the auditor master. But that the conversation is a little murky. Would you agree?
I agree that it's a little murky, which I think actually strengthens our position that how can you agree to something when there's no real meeting of the minds? Basic contract law, if Mr. Lewis wants to argue that there was some sort of agreement or contract would apply, then there's clearly no meeting of the minds. And if you'll note, I do reference Rule 53. I might not specifically reference Rule 53, but I recall saying something like, Your Honor, I believe that there's a rule on point, and that would be Rule 53, which I was thinking of, which relates only to the compensation of the auditor master or for his expenses or whatever compensation might be awarded. I certainly would never agree to an unknown amount of fees for something that I didn't think my client would have to pay for anyway. The auditor master proceeding is there to help the parties resolve issues. And if you're going to penalize one of the parties simply because they request that the court refer a matter for an accounting that will actually aid the court and the parties in saving time and expenses, that seems to be non-intuitive. It would sort of discourage that result, which might lead parties to not turn to that resource that the court has that actually does help parties resolve their matters. I do see that my time is up.
We'll give you a minute if necessary in rebuttal.
Excuse me?
We'll give you a minute if necessary.
Oh, thank you, Your Honor.
Mr. Lewis?
Yes, Your Honor. Thank you, Your Honors. May it please this honorable court, Todd Lewis on behalf of Ms. Thomas. I think I want to first start by saying that this is a 10-year case decided by the trial court. It seems in about 10 minutes, with no analysis of how the court had come to its conclusion. I apologize in advance for the fact that my briefs were seething with contempt for the parties involved in this matter, but I think that the context of the facts related to this case were important in the sense that this is not a case of a contingency slip and fall case. This is a case where Ms. Thomas, her property was foreclosed on with a non-judicial foreclosure proceeding, and the only way to remedy that situation was by hiring an attorney. So, how an attorney is compensated pursuant to the statute is important. I realized this morning the annotated statute in Lexis does not present any case law with regard to this matter, or with regard to how a court is to assess fees in a case like this. And I think that the trial court, really made the fee issue, I think, more complicated than it needed to be. Bottom line was the fees were reasonable, the fees were necessary, the fees were supported by the evidence. And if the court had taken an issue with the fees on a 10-year case, then the court should have held a hearing on this matter. We had requested a hearing as part of our motions practice in both the motion and application for fees. We'd also asked for a hearing in the motion for reconsideration.
Can I ask Mr. Lewis on the topic of a hearing? It is true that your motion for fees said, in bold letters, hearing requested, and it's true that when you sought reconsideration, also it said in bold letters, hearing requested or something equivalent. But there wasn't really, unless I missed it, any explanation in either of those filings about exactly what it was you hoped to prove at a hearing that you hadn't already included in the materials you were filing. Did I miss something, or?
No, I think you're right, Your Honor. In re-reviewing everything, I did see that as a matter of course, what was put in the pleading was request for oral hearing. Now, in the federal courts, that's sufficient. Federal courts in all the cases I've been involved in have, many jury trials. Request for hearing is sufficient to satisfy the rule, and the rule is it's not 54D. It's the rule's not coming to me right now, but right in the rule procedure it says, in quotations, oral hearing requested or something of that yoke. So in sense, Your Honor, I don't find that that line of argument persuasive insofar as, this is a 10-year case. We asked for, and I'll just approximate, a $250,000 attorney fee award. You can't work out that many hours. It's almost 400 hours in work. You can't summarize it in a pleading. I don't think. So in a typical federal case, for example, it's an employment law case where the trial track is maybe 18 months. Okay, I could see you could rule on the pleadings in a case like that, but a case like this where you have 10 years of litigation going on between parties, and much of the litigation is from the dilatory practices of the defendant, and a lot of the hearings and the work that was necessary in the case, stems from the court requesting these hearings. Now, mind you, I say hearings. The court status hearing used the status hearing as a bully pulpit to really push the case in the direction that the court wanted. Didn't offer any hearings.
Can I step back to a little more broadly to the legal framework and focusing for a minute on the issue that's being raised in the appeal by 3007th Street about the fees relating to the attorney's fees, your attorney's fees relating to the proceeding on the auditor master. Can you tell me what authority you're relying on by statute or rule that you think gave the trial court authority to award those fees?
Well, Your Honor, let's start with how the court. Let's start with the context of where the court was at the point of making the ruling. We were in a court of equity, which used to be a separate court. It used to be a court of equity, and there's broad discretion in a court of equity. We haven't raised the issue of Rule 11 costs, but I mean, in a court of equity, I think the court has discretion to grant fees where a party has been is asked for a particular in this case they asked for the auditor master hearing, and at that time, Your Honor had brought up that the record is unclear. I had raised this specific issue. Your Honor, I've been working here on this case with no fee. It's been a 10-year case, and here you're asking me to go and sit through more hearings for this auditor master hearing. Who's paying for all this? Who's paying for the auditor master hearing? How am I going to get paid for this? This is benefiting 3000 Street only because they wanted to offset the rent that they received for the 10 years. They wanted to offset those rents to any type of award that was awarded at the jury trial. So, that's the context. We're in the court of equity now. Whether Rule 53 applies or whether they can get pulled in the court of equity, for the Condominium Act, prevailing party provision. That's an interesting question, Your Honor, because I do feel that the Condominium Act does pull in 3007th Street. 3007th Street was started and operated by the board president, the condo board president. So the court can reach inside of the LLC and make a determination. Well,
on that theory, can I ask you about that theory? And also, I guess I have the same question about the theory that this was an equitable action and there's equitable authority to award fees. But the point, and also the point you were just referring to, which is sort of a piercing the corporate veil kind of point, were those theories presented to the trial court in connection with the request for fees, and were either of them relied upon by the trial court in awarding fees?
Your Honor, the case that was brought by 3007th Street, it's laughable. 3007th Street, the board president being the sole member, I believe, of that LLC. I think there was another member. It was the resident property manager who colluded with Mr. Buckley, who was to purchase several units at the foreclosure sales without notice to the owners of the unit. Mr. Buckley had actually done this to another unit owner and had taken possession of the property and ended up selling it for a huge windfall, like $250,000. So did we talk about that with the judge? 3007th Street had filed a quiet title action. A quiet title action in and of itself, Your Honor, is an equitable action. We had filed in the 2013 case our own quiet title. So I think it's very, very clearly delineated that we were in a court of equity. In that court of equity, I think that the court has that discretion. Now, who is the party that benefited from the services of the auditor master? Ms. Thomas surely did not. It was 3007th Street and 3007th Street only. In fact, they actually Mr. Buckley received a management fee as part of the award that was provided by the auditor master hearing. So he was the only party that benefited. I don't know if that answers your question, but in this case, the only way that Ms. Thomas would have gotten any type of result or moved forward in this matter would have been to have hired an attorney. I mean, there's no way.
I see that you're out of time, but I did have one other question that I was interested in you responding to, although it may, to a degree, anticipate a point that Mr. Lynch is making, but it relates also to something you just said. Can you explain how, with respect to the 2013 action, how your client could be viewed as a substantially prevailing party or prevailing party?
Sure, I'd be happy to, Your Honor. Actually, when I looked at the reply brief from the association, I mean, there was a moment there that I got a little depressed because I did get walloped. I got walloped throughout that case. And I think that begs the issue. The association hired a very competent attorney, Mr. Lynch. He's a very good attorney. And he's very convincing. And when you start reading the brief, you're like, well, what was the relief sought, and how did we get there? And look at all this protracted litigation, and it seems like Mr. Lewis is the bad guy. but really you have to look at the totality of the circumstances, Your Honor. And there was no, so who was the prevailing party and why? Ms. Thomas was indefinitely the prevailing party. She received the property back, and she received an award. What the court felt was, the trial court felt was the, bringing her back to the position that she was prior to the litigation, which was she received the difference between the rents received and the expenses. You cannot look at any one motion hearing in isolation in terms of awarding fees. I think you have to look at the totality, and I think the case law speaks to that. But more so, I think that there's a public interest argument here that you have to compensate attorneys that are taking cases like this on. In hindsight, I don't think my wife would allow me to take a case like this on, where it disrupts 10 years of vacation plans, 10 years of having to sit through dilatory and litigious briefing. This type of case, I think a message has to be sent to the actors in a case like this, that you can't get by in dragging a case out and expect not to pay for it at the end in terms of compensating attorneys for being there. I mean, Your Honor, the court blanketedly, and I'd like to add, as attorneys, we're not allowed to block bill. And here in this case, the trial court discounted my fees by 50%. Did not even consider Ms. Roan's fee when the court even acknowledged on its own court that Ms. Roan's was due a fee, but based on a technicality, was not getting it. And so here we're in the court of equity in 1 minute, and then in another minute, it's all forgotten. So I think that the facts very clearly state that Ms. Thomas was the prevailing party, Your Honor. I don't know if that answers your question.
Judge Cookman, you're muted.
Sorry, I was talking and I was muted. Counsel, what we'll do now is we'll hear from Mr. Lynch, who represents James Buckley and the association and that group of defendants or appellees. And then we'll give you a few minutes to respond, since he's the appellant in that matter. Do I have that right? Actually, maybe I don't have that right. You're not the appellant in that matter. You're the appellee in that matter, right? I take that back. But we'll give you a few minutes to respond after he speaks. Mr. Lynch. Mr. Lynch, now you're muted. Mr. Lynch.
Is that better, Your Honor?
That's better. Thank you.
Thank you. Apologize.
You may proceed.
My wife is my assistant, and she's much more proficient in these things. I just want to cut to the chase and address the issue that Judge McLeese brought up. And that is, in my case, Hazel Thomas was not the prevailing party. And there has been a lot of litigation filed. And in the federal court case, which was the DJ action involving Travelers Insurance Company, all of the filings said the 2013 case was not over, that all of the legal issues had not been decided. And I will quote, and this is from plaintiff appellant's own briefs. The District of Columbia Superior Court made no legal conclusions, legal findings, or evidentiary rulings regarding any of Ms. Thomas' claims in the case number 2013, et cetera. Rather, it simply closed the case to allow this honorable court to adjudicate Ms. Thomas's claims on the merits.
Mr. Lynch, may I ask you about that? I don't necessarily understand why Mr. Lewis said that, what it meant. But my impression was that Ms. Thomas did prevail in the 2013 case because she had the foreclosure essentially vacated, and the property was returned to her. Why isn't that prevailing in that case?
Well, Your Honor, through the course of the litigation, there was much more to her than getting the property back, to her claim than getting the property back. She did at one time, we had so many hearings on this, but at one time she did decline to take the property back. And then she changed her mind and did take the property back. And then there was all these filings in federal court arguing that nothing had happened. So our central position on this is that you can't get attorney's fees on issues that have not been litigated, and the case is not over yet.
Well, but it was well. The 2013 case is over with. That's why it's on appeal. I mean, it went up once to this court, and that was an appeal in the 2013 case. And Ms. Thomas prevailed in this court in the sense that this court overturned the decision of the trial court, and she got back her property. Now, you might say she didn't get everything she wanted, but that sounds fairly significant. Significant enough so that in principle, one would think she could, if she were otherwise entitled, seek attorney's fees for them. On that score, so that's the way I've been looking at this, and I don't hear you saying, I don't hear you directly disagreeing with that.
I cannot disagree that she did receive the condo back. Our first and primary argument is that she did not substantially prevail, and just by the admissions of their own writings.
Now, with regard to that argument, let me just ask you, with regard to that argument, you have not, am I correct? You have not taken, your party, your client, have not taken a cross appeal from the award of attorney's fees to Ms. Thomas. Is that right?
That's correct, Your Honor.
So you are not before us asking us to vacate the award of attorney's fees to her. Your position is simply that's what you're stuck with, but she shouldn't get done more. Is that right?
Well, the primary argument was, yes, they had not substantially prevailed to get the attorney's fees, but the secondary argument was that the trial court did not abuse its discretion in coming to the award of $37K because the proof was deficient. They had the burden of proof. It was so complicated and just impossible for the trial court to figure out which bills went to 2012, which bills went to 2013, which bills went to the federal court. Our position is the trial court did their best and there was no abuse of discretion.
Can I ask you to clarify? I want to make sure I understand and make sure we're using the terminology the same about which cases, the 2012 case, the 2013 case, because I'm not sure we're all on the same page, so maybe you can help me. My impression was that there was an initial action filed in 2012 that was filed by 3000 7th Street, and that it's in connection with that action where the case went up to the Court of Appeals and Ms. Thomas, the foreclosure sale was set aside and there were proceedings relating to what was going to happen in connection with that. And then the 2013 action was filed. And so I may have this all confused. I see Mr. Lewis is shaking his head, so he'll maybe be able to clarify this. Am I misunderstanding who the parties were in which action? Can you just tell me, like, who were the parties to the 2012 action, what relief was obtained? Who were the parties for the 2013 action, and what relief was obtained, if any? That's a question for you, Mr. Lynch.
Oh, I'm sorry, Your Honor. I thought Mr. Lewis was going to chime in on this one. The first case was brought by Mr. Thompson in 2012. The second case was the 2013 case brought by Hazel Thomas, and the cases were consolidated. And we've all been together for the last decade. And,
no, I understand they were consolidated, but just in terms of what relief was requested in the, I thought the first suit was a quiet title action. and that the trial court ruled, and that was initiated by 3007th Street. And the trial court ruled in 3007th Street's favor, and an appeal was taken to this court by Ms. Thomas, and this court granted relief to Mrs. Thomas. Is that not correct, or is that correct?
Mr. Lewis, do you want to?
Well, no, I'm asking you, Mr. Lynch. If you don't know, we can talk to Mr. Lewis.
I do know, Your Honor. The 2013 case involved a myriad.
I'm asking about right now. I'm asking about the 2012 case.
I can explain, Your Honor.
Well, you'll have your chance to. Let me just make sure I understand what Mr. Lynch.
I was not a part of the 2012 case, Your Honor.
Got it. Okay, that's fine. Then I'll explore that with the parties to the 2012 case. Can you tell?
Well, Mr. Lynch, if I can just chime in, Mr. Lynch, you were part of the appeal to this court in Thomas versus Buckley that this court decided in 2017, in which we held that the association failed to provide the unit owner with adequate notice of the foreclosure. Correct, Your Honor. And all the parties who are now before us, that is to say, not simply 3007th Street, but also James Buckley, University Hall Condominium Association, and Hilton Bernstein Management were parties to the appeal as well. And my understanding, I could be corrected on this, but my understanding is that this was an appeal taken in the 2013 litigation, the 2013 case. And as the court said, this decision applies primarily to UHC, the condominium association. Yes, sir. So I had read this decision as being a decision in reversing, I mean, in effect, granting relief that was requested in the 2013 case. As all, I mean, it may also have been requested in the 12 case. I'm not trying to limit that, but
it looks as though it was a consolidated appeal, because also 3007th Street, which was not a party to the 2013 action, was a party that appealed to.
I think 3000. Am I correct? I think
we can ask, but in any event, it's definitely, you're right, it's a consolidated appeal. And there were all parties. It's a little murky to me, I guess, in which of the cases, what kind of relief was granted. I'm not sure our earlier opinion was so clear. But in any event, so it sounds like we'll hear from Mr. Lewis and also from Mr. Thompson about kind of how they understand, which case is the 2012 case, which is the 2013 case, what relief was granted in which case. But Mr. Lynch, just as far as your case goes, the 2013 case, do you understand the relief that was granted by this court in the earlier appeal to apply not only to the 2012 matter, but also to be rooted in part in granting relief to Ms. Thomas with respect to claims that she was pressing in the 2013 action?
Yeah, I do, Your Honor. There was initial motions for summary judgments granted, and then your court sent it back down and said it returned the condo to Ms. Thomas if feasible. But going to our central point again, there were many other claims involved and are still being litigated in federal court. And the DC Superior Trial Court, I believe, when the judge closed the case, in his mind, he was letting the federal court handle the rest of these claims.
Can I ask you, you agree, though, that whatever Mr. Lewis may have said in his filings, you agree that the 2013 case is now over in Superior Court? Or do you think it's actually not over?
Yes, I would agree that it's over, because the judge closed the file. He used that word "close" and said that this is all still happening in federal court.
So then the question then does become, if the relief of returning the condominium to Ms. Thomas, if possible, and if not, then kind of unscrambling the egg in whatever way one could, if that was issued in part, at least in the 2013 case, then why isn't Ms. Thomas a substantially prevailing party in that case? Because that is, a significant part, substantially prevailing party. That's a significant aspect of what she was seeking in the 2013 action.
Yes, Your Honor, I understand that, and she did get the condo back, and what our argument was in the alternative that if you don't find that our first argument to apply that we are okay with the judge's ruling us to the 37K based on the information, the evidence, the conflicting testimony. You had billing on 3 different cases. Our secondary position is that the judge did not abuse his discretion in coming to that award.
Your Honors, was I given a total of 15 minutes to speak?
We'll call on you in a moment, Mr. Lewis.
Yes, sir.
Okay. Mr. Lynch, do you have anything you want to add?
No, Your Honor, thank you.
Do any of my colleagues have any further questions for him? No. Good. All right, Mr. Lewis, we will give you 5 minutes in rebuttal.
So I would like to point out a couple of things. First, adding the federal court action into this case is really just nothing but subterfuge. What was said in that case really had to do along with the lines of res judicata. So it's our position.
I think, Mr. Lewis, I think the issue for you is to explain to us, if you can, how the trial judge in this case abused his discretion in awarding you only $37,000 in attorney's fees from what I'll call the association defendants. There were manifold problems, as the judge pointed out, with your fee submission. And even in your motion for reconsideration, you did not address those problems. So how did the judge abuse his discretion?
Well, as I pointed out earlier, Your Honor, having 10 years of litigation reduced down to a pleading.
It's done all the time. It's done all the time. You keep accurate time records, and if they're 10 years in length, they're 10 years in length. But that's what is expected. In this case, the judge carved out a lot of expenses that were clearly not recoverable in the 2013 litigation. Carved out a few other things, and then said, now as for the rest, I'm paraphrasing a bit, I really can't make too much of this because the descriptions are just rather vague. So what I will do is just cut it by 50% and give you half, which it could be said that's somewhat arbitrary, but that's what the judge did. I don't know how you can argue that given the problems with the time records, it can be said that you were that the judge abused his discretion.
Your Honor,
that's what I want to hear.
Yeah, so I would submit that what's good for the goose is good for the gander. If attorneys are not allowed to block bill, I'd say that judges are not allowed to decimate an attorney fee award. And the motion to reconsider, Your Honor, we addressed every single issue that the court had raised in its ruling, its original ruling on the application for fees. I would like to note.
Can I just ask you about that, Mr. Lewis? One of the concerns the trial court had was the trial court's view was fees were just for legally unavailable in the 2012 litigation because of what statutory authority was available. And the trial court's original order said, well, I can't pull apart these billing, this billing as between the 2012 and the 2013 litigation. Did the motion to reconsider address that by pulling apart the bills and allocating what aspects of billing went to which?
Yeah, I have it open, Your Honor. It's a spreadsheet that it took hours to build. We separated out everything that the judge had talked about in his original order. I think it's worth noting that the judge—
Just to be very clear, I mean, you're speaking more generally. If I look at that spreadsheet, all the entries will say clearly this related to the 2012 litigation, this related to the 2013 litigation?
Well, so to answer that directly here, let me open it up so that I can answer it, and make sure that I'm answering you honestly. But, one thing while I'm looking for this, Your Honor, I'd point out is that the expenses, there were no expenses provided. So there was $0 given for expenses. And it's worth noting in the motion for recon, we pointed out to the court that there were $1,700 in transcript fees that weren't awarded and weren't even considered. So, you know, let's see, we distributed the cost in our spreadsheet. We separated by auditor master, communication, drafting, hearing, preparation. So it doesn't specific and expenses. It doesn't specifically delineate which case we were in because it was never an issue between the 2012 case and the 2013 case. So let's just stop for a second. Let's talk about the difference between the 2012 case and the 2013 case, or how it all came to be. 2012 case, you got 3007 Street, who is the reported purchaser of the property in foreclosure sale. I mean, this on its face it's not, it doesn't pass muster. They didn't follow any corporate formalities. The trustee did not follow his duties as a trustee. They accepted fees after the fact for the foreclosure from Mr. Buckley. The LLC wasn't set up until after the sale. There was no quorum for the meeting. They voted by email. No notice to residents of the foreclosure sale or of the meeting to have the foreclosure sale. That required a special meeting notice. They didn't have that. You know, they were not considered a bona fide purchaser by virtue of the fact that Mr. Buckley was the LLC member and he was the president of the board. So you can't have your cake and eat it too here. So going back to your original question, Your Honor, you know, the difference between the 2012 and the 2013 case, 2012 case brought by 3007th Street to quiet title. What were they asking for? They couldn't get title insurance on the property because there were defects for the foreclosure sale. So Mr. Thompson is a title attorney. He knew that there were defects with the sale. So what did? They filed a quiet title action. They filed a verified complaint, I would like to add. The fact that it's a verified complaint means that they verified all the facts. Okay, but that on its face is inaccurate because they knew that there were title defects. So they couldn't, they had to present the title defects as they were in the complaint, but they didn't do that. They moved forward. We couldn't get anywhere in discovery on that case because they said that the LLC was not a party to the foreclosure sale, or they're not a board member, et cetera. So they had really nothing to give to us. We couldn't really get any information. And it was in the 2012 case that we discovered that Mr. Buckley was the board president. He purchased the property at foreclosure sale. He set up his LLC with a resident property manager from Tilden Bernstein, and they conspired to purchase multiple properties from unit owners, all elderly African-American property owners in this condo association. And so I'm just going to stop there. The 2013 case, we were in the 2012 case. It was on trial track. And I really couldn't get any traction because you can't really, I had no way of pleading against or, you know, I couldn't get the case closed on summary judgment because the posture wouldn't allow for something like that given the circumstances on how they pled it. So we filed 2013 case, which in essence asked for the same type of relief that Mr. Thompson asked for in the 2012 case, the quiet title, but we went a little bit further and we asked for an abusive process claim. The abusive process claim was the only claim that had survived. That in the quiet title action was the only two claims that had survived both cases. And so, you know, the abusive process claim was not ever decided. It was really the quiet title action in both cases where the judge, I think the trial court had jurisdiction over all parties. Think about this, it's absurd. 3007th Street said that in the 2013 case that they were not a party because the original judge, Judge Nash, had said that service on them was not effective. But yet they participated in the appeal, everything. And yet they continued on this posture. So they only filed items in the 2012 case. So there's two dockets. Okay?
Mr. Lewis, are you essentially saying that the two cases were the same case and you were entitled to fees in the second case, so you should be entitled to fees in the first case?
Thank you, Your Honor. I've not ever been accused of being the smartest guy, and I think you summarized it best. Yes, Your Honor. I think the court of equity, in both the 2012 case and the 2013 case, I think the trial court had the ability to assess fees for all defendants by virtue of the circumstances. And that's where the court erred. The court erred because.
And if
all
we go
parties-
back and look at your brief, you've cited some authority for that proposition?
The authority, see, here's the thing, you have to read between the lines, Your Honor. You have to look at both complaints. Both complaints, quiet title action.
I'm not talking about facts. I'm talking about law, right? Because the question is, on what basis did the court have to grant you fees in relation to the 2012, right? You're here saying, I didn't get enough money because the court didn't pay me for the 2012 case. But the 2012 case was the 2013 case. They were all of a piece. It was all the same. And I'm just asking, as a legal matter, will we find authority in your brief supporting that rationale?
I think so, Your Honor. I mean, I can't cite the specific case law, on hand right now, but I do think you will. I think that, this whole notion of these two separate actions, or whether to consider one party as opposed to the other in a consolidated case, in the posture that it was, I think it's subterfuge. And the abuse of process claim was not ever considered, which is why I raised the issues at the federal court, because think about this, Ms. Thomas, involved in a 10-year litigation, after like 8 years, gets sued in federal court by the insurance company, by one of the insurance companies for the association, saying that she was a necessary part of the litigation, really didn't have a claim against her, only, they wanted this summary judgment that they didn't have to pay insurance on the insurance policy based on the abuse of process claim. So we filed a counterclaim in that case because there's a clause. We didn't ever get insurance documents in discovery.
Wait a minute, Mr. Lewis, I don't know why we're talking about the federal court case.
Okay.
That case is not before us, and you're not getting any attorney's fees from this court or from the Superior Court for work done in the federal court case. And I think you agree with that.
Your Honor, I'm not agreeing. I submitted my time records as they were. The court, I was being honest with the court. These are my records. I keep, pretty copious records of my time. I use a client management system. I am not a contingency fee attorney. The work that I do is usually these types of cases, especially back then. My bleeding heart went out and listened to Ms. Thomas's circumstances. It was her nest egg that had gotten taken. She didn't have a mortgage on the property. The association board president took the property at foreclosure sale without telling anyone that he was going to do it. He's a real estate agent. He should have known better. All of these things. I've been a real estate agent for 20 years. My bleeding heart listened to that. I was like, I have to take this case and help her, not knowing that it would be 10 years later that I'd be talking to you here. And, then the court made this distinction between the 2012 case and the 2013 case. And,
well, that distinction is important, Mr. Lewis, because in the 2012 case, which went on for a year or so before the 2013 case, the only defendant was 3007th, the only party, you were the defendant. The only other party was 3007th Street. And there seems to be no statutory basis or basis in the rules for an award of attorney's fees against them. Now, there is a statutory basis in the 2013 case for an award of attorney's fees if you're the prevailing party against some of the association defendants. And
I can speak to that. I do have an argument.
Well, I think we've gone through this enough. I think we're finished with your rebuttal time.
If you could just give me one brief second.
Okay, I'll give you one brief second.
So on that corollary, if you look at the DC Condominium Act, under the provisions for attorney's fees, it looks at the decisions made based on the business judgment rule, and the actions of Mr. Buckley, because he was board president, allow liability to attach to 3007th Street by virtue of his actions, because it violates the business judgment rule. If you read what the business judgment rule says, and I'm trying to
you didn't get any judgment. The only judgment you got in the 2013 action was a judgment essentially returning the property to Miss Thomas. Is that correct?
No, we got a financial award.
Well, I know it was an either or, right?
And she got 10,000 from 3007th Street, which they did not.
I'm sorry. I only meant I meant only the association defendant.
So
parties.
yeah, the association did not pay anything. 3,000, and again, 3,000 Seventh Street received or was the trial court awarded the fee from 3,000 Seventh Street. And I mean, this whole distinction between the 2012 case and 2013 case, I see where Your Honor's what Your Honor's talking about that is relevant. But for my purposes and for the trial court's purposes, we didn't ever really distinguish it until it came up for fees. And then, it's kind of like, I gotcha, you spent all the time on, and I'm not, look, the time is what it is. The time was spent on each case the way it was. I'm not trying to get double compensation. I'm not trying to put compensation elements out there that I don't think are relevant. I'm just submitted my records as they were to the court. And unfortunately, the court came back the way it did. But I mean, just look at Ms. Thompson's expenses. I mean, the judge had asked for receipts. I mean, can't we have an evidentiary hearing on receipts? I mean, I didn't know we were going to, or give us an opportunity to respond or something. There was not one motion hearing in all the time that we were before Judge Hugh Lugo. So, to separate this and make it more confused with the 2012, 2013 distinction, I think is really it's impossible for a court to parse out fees on its own accord without having a hearing on something like this. I mean, that's not my only argument on, but 10 years of fees. Judge Glickman, you said that, this happens all the time. I mean, okay, but those cases are cases where, it's probably a case where the attorney is prepared for that. I mean, this was like it was like a bootstrap case where we're trying to get Ms. Thomas her property back. It's her only asset. She had, it's her retirement fund. And, here we got 3007th Street saying, we're not a party to the 2013 case. It's a fiction that was created by 3007th Street or 3007th Street. And they parse it out when they want to use it and when they don't. And, it's funny how they got remedy from the auditor master and they asked for the auditor master hearing. And yet, they're saying, well, we're not responsible to pay for the fees. Liability for attorney's fees is passed at the appeal. I think Your Honors has made a good point. Liability is passed at appeal. And all parties were on notice after appeal that attorney's fees were in play by virtue of the Condo Act. And yet they still decided to dilate this matter and continue on in the fashion that they did. So, I don't know how you can incentivize people to stand up for someone whose property was taken at a non-judicial foreclosure sale, where she didn't have a mortgage on it, where the board president is the one that purchased it, who would not.
Hey, Mr. Lewis. Mr. Lewis, I think we've heard your argument. We'll consider it, and the case is now submitted. Well, the cases are now submitted. Counsel, you may log off. Thank you.
Thank you.
You may log off now, counsel. We will now call the third case on the calendar, KHAWAM versus WOLFE. We will now call the third case on the calendar, KHAWAM versus WOLFE.
Good morning, Your Honors. Your Honors, good morning. I need to figure out how to turn off the YouTube feed. Give me 1 second, please. There we go. Is that better?
That seems to be better. You may proceed.
Okay, but now I can't hear you. Judge Glickman, would you be able to speak so I can tell if I can hear you?
Can you hear me now?
No. We tested this earlier and everything was working and I could hear it, both preceding arguments perfectly. So
We can hear you
I-
fine. I am not muted.
I suspect she's turned off her internet audio. If the courtroom clerk could give her a call and instruct her what to do.
I can't hear you either, Judge Easterly. Should I call into the phone number to try to get this resolved? I obviously can't present oral argument if I can't hear you.
Okay, can you give me your number, please? Can I get your number, please?
She can't hear you either, I bet.
No, my audio is on.
Okay, I'm gonna leave my number in the chat. You can call that number.
Write your number on a big piece of paper and hold it up to the screen. No, don't do that.
I'm sorry, I can't hear you. Unmute. I need the former fellow's wife to come help me.
Okay, I left the number in the chat. That's my personal number. You can call it.
I'm sorry, I can't hear you. I know you're trying to speak. It's very faint.
Can you look at chat?
I'm sorry, say that again, Judge Glickman?
Can you look at the written message in chat?
If you can check the chat, my personal number is there. You can call me right now.
Let us take a 5-minute break. Could the clerk send us back to the waiting room, please? Or to the breakout room?
Yes, Judge. Yeah, we're going to take a short recess.
Thank you. And you can come back for us when this gets resolved.
Mr. Green,
Yes,
I cannot hear you. I think
I hear
there's
you.
some kind of
so
problem.
if you can look on your settings on your computer and choose microphone, because right now your mic is off.
Yeah, can you talk right now?
Yes, I'm talking right now. So if you can, 1 sec.
When it comes to sending your boss.
One second. This court is back in session. Please come to order.
Thank you. Ms. Khan, I gather we have resolved the audio problem now, and if that's true, you may proceed.
We have apologies for that technical problem. My name is Aisha Khan. I'm here on behalf of the appellant, NATALIE KHAWAM. I'd like to reserve 3 minutes for rebuttal, and may it please the court. This case has bounced back and forth between the trial court and this one, so I'm not going to spend much time informing the court about the background. But I want to start by saying the court has long held that an attorney fee award has to be premised on 2 analytical steps. The first is an assessment of whether an award should issue, and the second is an assessment of the amount of the award. In analyzing the second of those questions, a court can consider several factors, but what it cannot consider are the motivations and behavior of the party being asked to pay, as well as the burden imposed by the litigation on the party requesting fees. And that's,
right, and that's why we sent it back. And so where are we now?
So this court reversed attorney fee award entered in 2012, and in doing so, it relied on the trial court's statement that it had, in fact, relied on those 2 impermissible factors. And in fact, this court said the trial court had explicitly based the amount of the fee award in part, and I'm quoting here from 460.
Ms. Khan, I'm trying to abridge your argument. We're aware of what the court said in 2012, and we're aware of what the court said post-remand. And so I'm trying to get you to the point where you explain to us why what the court said in 2019 was unsatisfactory, improper, reversible error for the 3rd time.
Yes, Judge Easterly, I'm happy to turn to that. On remand, despite what the court had said earlier, it said that those impermissible factors had in fact made virtually no difference, and it reduced the award by $25,000 nonetheless. So there's several problems with this. First of all, it makes a mockery of the appellate process if after this court reverses, the trial court can simply say, I didn't mean it. Here it's even
But
more.
why does it do that? I mean, because what we said in KHAWAM 2 was we can't say that it's harmless, right? We were engaging in a harmlessness discussion and we said we can't say that it's harmless, but we didn't say that it was harmful, and we didn't remand to say you must reduce the award. What we said is go back, reconsider, strip all improper considerations from your attorney's fee decision-making, and tell us how much in the way of fees, or tell the parties how much in the way of fees is owed. We didn't invite the parties to come back to us, but certainly it was implicit that if what wasn't done wasn't proper, that, that another appeal was possible. But here we are in appeal, and I'm not seeing why what the court did was improper. The court said, I took out the improper considerations, and my decision-making is the same, but in an abundance of caution, I'll deduct $25,000 from the bottom line just to make sure that nothing improper influenced my thinking. And, here it is. I think that, $325,000 in the way of fees is appropriate in this case, based on permissible factors.
Judge Easterly, let me kind of push back a little bit on your assumptions there. This court said, again, that the trial court had explicitly based the amount of the fee award in part on the impact of the litigation on Mr. WOLFE and the bad faith motivation of Ms. KHAWAM. And let me try to.
Yes, we did say that. We said that was part of the decision-making process. That's very clear.
Exactly.
We also said it is quite possible that the court's decision to fix the fee award at $350,000 was affected. We didn't say that it was affected and that a reduction was required. We just said it's quite possible. And so therefore, we're sending it back, take out the improper considerations, and reconsider the award.
Your Honor, here's what the court said, okay, in 2012. The burdensomeness to Mr. Wolfe and the bad faith motivation and behavior exhibited by Ms. KHAWAM weigh heavily in favor of a substantial award of attorney's fees. There was no ambiguity about whether those factors played a role in the amount. The fact that this court might in 2014.
Well, I think we're missing each other here, because I could say, you know, I'm going to make decision X. I have 5 reasons to make decision X. 3 of them are really good reasons. 2 of them are very bad reasons, right? But I have 5 reasons that I'm making decision X. And then on reconsideration, I can say, you know, reasons 4 and 5 are bad reasons. Forget 4 and 5. I shouldn't have ever said that those were good reasons for my decision making. The reasons 1, 2, and 3 were good foundations for my decision. And I stand by those 3 reasons. And so I stand by my decision. Why is that not possible just as a theoretical matter? I feel like that's what you're fighting about.
Because it asks us to walk through the looking glass into Wonderland. I mean, on the one hand, he said, he's now saying I meant the opposite of what I said, right? Earlier, he said these 4 factors counsel in favor of an amount X. Now he's saying, actually, those 2 of those factors didn't matter at all. So let me give you a hypothetical, and this one's going to be extreme, but I think it captures the point. What if a court said, I rule against the plaintiff because he's Black and then there's something permissible, and you reverse and you say race can't be considered in the analysis. And on remand, the court says, my ruling had virtually nothing to do with race. You wouldn't buy that any more than you should buy this. We care.
Well, in a case like that, of course, we wouldn't be sending it back to the same trial judge, and the trial judge would have a lot of other problems. But in a case where it was something that was, less offensive, and a trial judge said, I'm granting summary judgment, and I have 3 reasons, and the court of, I have 3 reasons. Well, we could perfectly well, we might even affirm a ruling like that if they're independent reasons by saying, well, you gave 3 reasons, one of them doesn't work, but the other 2 do work, and they are sufficient to justify your conclusion and would require it. So it's very contextual whether someone who's given a number of reasons for ruling, if told, well, one of those reasons work, has to rethink, doesn't need, obviously you need to rethink, but you might reach the exact same result. And it seems another assumption of your argument is any one of the reasons the trial court relied upon has to have had like a marginal economic impact. So that, if the judge gave 5 reasons, one of them, the judge would be thinking, okay, it's $37,000 for reason A and $15,000 for reason B, and they all add up to $350,000. And the trial court obviously didn't allocate the amount among the reasons in the initial reason. And one way of looking at the trial court's statement on remand, opinion on remand is, those were all contributing reasons. They were relevant. I was thinking about them. Although the trial court was a little cagey about that. The trial court did say, I may have, appeals thought I may have relying on them. But they don't change my bottom line. They are like independent alternative reasons. And if one of them is gone, I think the total amount of necessary payment would be the same. There's nothing intrinsically unreasonable about a decision like that. So if I don't think. So I think your argument has to be a little more detailed about, why here we should think that's not a reasonable way for the trial court to have, be characterizing its original thinking and its thinking after remand. Not because you can never do that, but because there's something special about this setting. At least for me, I think when it's worded more broadly, I find it not necessarily intrinsically persuasive.
Well, I think Judge McLeese, your example is about summary judgment. That's an up or down vote. It makes eminent sense to me that you could say the plaintiff still wins if I remove that impermissible consideration.
For sure, it's a completely distinguishable situation, and I recognize that. And my point was, And that's why I gave another example also about like marginal economic value of different reasons. Because this is not an up-down ruling. This is like a, where along a spectrum, a dollar line spectrum. And the point I was trying to make by the first example is it's context dependent. If a judge gives several reasons for a ruling and is told one of them doesn't work, it may or may not change, rethinking and setting that aside may require or not require, or, it may vary whether it does or doesn't require or would persuade a judge to rethink. It's all context dependent. It's not an intrinsic feature. The judge had 5 reasons for a conclusion. 2 of them were invalid. Therefore, the conclusion has to change. That's not at that level of generality. That I don't think that's a persuasive line of thinking. It has to be something that is more specific or concrete to the setting. That's what I was trying to illustrate by that example, and then also the question about kind of marginal economic value of each reason.
Well, the statements that the trial court made in 2018 were not consistent with the conclusion that there was only marginal value attributable to these impermissible considerations. And I say that because it's actually 4 factors that the trial judge said weigh heavily in favor of substantial award of attorney's fees, and 2 of them were impermissible. So this is not a circumstance where there's a great number of factors and only one needs to be excised, and you might buy that you reach the same conclusion. But even more to the point that I think you're driving at, this attorney fee award cannot be read in isolation. I actually want to make 2 points, but let me start with this one. I can't cover it all, but if you read pages 41 to 42 of our brief, this is a case in which there's been a steady drumbeat of pretty unusually hostile statements about my client. And it was throughout every single piece of this litigation, my client was essentially punished because the trial court concluded that she wasn't telling the truth about a domestic violence allegation. And I'm not going to have time to cover every illustration, but the verbiage is so harsh and so personal. It's essentially a character assassination. And there are a lot of cases where there is affirmative evidence that a party is lying, but this is not one of them. What we have is a possible.
So I think actually, the court looked at both parties in this case back in 2012 and said, neither of them are particularly honest. Both of them have, misrepresented things. Mr. Wolfe on his taxes, I think, was one example. But in a sort of comparative assessment of dishonesty, I think the court said, and not just based on the domestic violence allegations, thought that your client was more dishonest than Mr. Wolfe. And it was based, in part, I think, on the underlying facts of her absconding with the child, and based on, her failure to be fully forthcoming about her financial situation, which sort of bleeds into your second argument. So I think it's not accurate to say that the record reflects that the court was really looking at your client, condemning your client for what not just the trial court who issued this attorney's fees ruling, but other trial judges who were involved found were unsubstantiated allegations of domestic violence. I just don't think that the record supports that. You're running low on time. I do wonder if you want to turn to your second argument about the obligation to consider current financial circumstances.
Yes, Your Honor, I would like to cover that, and it actually blends, it sort of follows logically. So what we got on remand with respect to the permissible factors, one of which is the ability to pay, is a block quotation of what the trial court had done earlier. And even with respect to those, the trial court could not turn off the punitive switch. And let me give you an example. With respect to her ability to pay, and this is at the Supplemental Joint Appendix 193, he says, first, he suggests she was falsely claiming unemployment. Even Mr. Wolfe didn't contest that she was unemployed. Even the trial court himself set her income in the child support worksheet at $50,000, which was based on a.
Did you make an argument in your brief that the court had made erroneous findings of fact? I thought your argument was a legal argument that the trial court in 2019 was obligated to consider current circumstances and in particular net income.
Yes, that was our position, that there was a pending motion for child support that would have brought before the court the parties' financial situations. If the issue is the parties' ability.
What support did you give to the trial court in support of the argument that he had to consider current financial circumstances with regard to a 2012 attorney fee award?
Your Honor, there's no case law on a situation like this. This court did not speak to the question of
right,
whether.
but you cited cases to us in our brief, and I'm just asking, did you cite cases to the trial judge?
I'm not sure what you mean, Judge Easterly. We cited cases in our brief. The brief is in the supplemental joint appendix. But what we told the court is that it's based on ability to pay. I think Granby is one of the cases that.
I mean, I'm just looking at your brief on remand on page 10. Your ability to pay argument just says, here's an affidavit about her current circumstances. But there's you didn't cite any case law like you cited to us about the requirement that he update the current circumstances, right?
You said page 10. Are you able to give me the?
I'm on the supplemental joint appendix at 166.
Okay, I'm opening it up. Yeah, well, early on, I believe. Yeah, I don't see cases cited there. I think that, honestly, I don't really think this, I think this is more like a common sense point, that if the question is the ability to pay, what someone could pay 7 years ago doesn't matter. But it
okay, but one question then related to the common sense point is, you know, this is 2019 and you're saying, well, look, our ability to pay now is very different. Well, I maybe that's not correct. Is your argument that your ability to pay is very different now than, or not even now as we sit here? Your ability to pay when the court was looking at this post remand in 2019 was different than your client's ability to pay in 2012? Is that the argument?
Our argument is twofold. Yes, that is true, but it doesn't matter. The judge did not make a finding of her net income with respect to 2012.
I don't want to get to net income yet. I just want to talk about ability to pay and when we're looking at it.
Yeah.
And I guess, I mean, that's interesting, right? Because as far as your client's ability to pay in 2012, what the trial court found in 2012 is she seems to be unemployed. She doesn't have any net income in 2012. But she seems to have people who pay for things for her, right? She has access to her sister's credit card, and somehow she has an assistant that she shares with somebody else who gets paid $50,000 a year. And she, you know, they're just how she's living is not entirely clear, in part because I think your client didn't put in front of the court terribly detailed financial information about where she was getting money from. So I'm curious to know, you know, now your client is saying in 2019, she's working and she's making a salary. Why would we consider that as a reason to go back again on and ask the trial court to reconsider ability to pay?
Because there's never been an assessment of her net income. There wasn't an assessment.
So you're saying there was not an assessment of her net income in 2012?
No, there's never been.
So in 2012, the court, I would say, I mean, made a reasonable assessment of her net income insofar as the court said she doesn't have any income. And she doesn't seem to have any debts either, because people are paying for her, and she has testified that she doesn't have an obligation to repay those debts. You know, I guess you can quibble about whether or not that's technically a requirement of net income, and I really don't want to get to net income, but one question I have is, if there was not an assessment of net income to your satisfaction in 2012, why wasn't this raised in the KHAWAM 2 appeal?
Why was it not raised in the KHAWAM 2 appeal?
Yeah.
Well,
when you argued that impermissible factors were considered, why wasn't it also raised that the court hadn't adequately considered ability to pay in 2012?
Okay. I feel like you've said a lot, Judge Easterly, and I haven't really had a chance to answer the first, what you were saying at first. I hope I can get back to that. But with respect to whether it was raised, the trial judge's 2012 assessment of her income was deeply intertwined with its consideration of the impermissible factors. And we can see that at Joint Appendix 449, where this is what the court said. Although Ms. KHAWAM may claim to have difficulty paying the fee award in the immediate future, she should bear at least this share of the extraordinary financial burden her even more extraordinary conduct has imposed on Mr. WOLFE.
Ms. Khan, this may be a long windup to answering Judge Easterly's most recent question, but it doesn't seem to be getting there quite yet. I mean, her question was, why didn't you raise as a separate argument in the appeal brief in KHAWAM 2, the judge got ability to pay all wrong. It, was attributing income to my client that was really, the generosity of her friends and family, and that's not appropriate, and should have done a lot of other things. And so, saying what the trial court's order, that the various things were intertwined, I'm not sure. I mean, again, maybe it's the prologue to an answer, but is there a direct answer about why, if you thought the 2012 order was just flawed substantively on ability to pay, why that wasn't a separate issue raised in the KHAWAM 2 appeal?
Well, we were focused on the punitive, hostile approach that the trial court took. And this court said, go back down and again, reconsider the permissible factors. So the fact that we didn't lay out in all detail the impermissible aspects regarding net income doesn't change that this court remanded for the court to undertake a reconsideration.
We did, and we thought that you had a winning argument in KHAWAM 2 as far as the consideration of impermissible factors. But there's a judicial efficiency argument to be made here, right? Of arguing this piecemeal, and we're still arguing about fees in relation to a 2012 award here in 2019. And it seems to me that right now you're putting information before us and before the trial court on remand after KHAWAM 2 that are talking about your client's financial health in 2015, 2016, 2017, 2018. These were arguments first of all, to the extent that you thought that the 2012 order was misguided on a different ground, it's hard to understand why that wasn't brought to us when you argued that there was consideration of impermissible factors when you appealed KHAWAM 2. But second of all, it's also hard to understand why the argument wasn't made, hey, and on remand, if you agree with us that impermissible factors were considered, you need to tell the trial court to consider my current financial situation because it has changed in a material way, right? And that argument just wasn't made. And now we're being asked to consider what your client's financial situation was back over some period of time. I mean, it seems like if we buy into this argument, we're on this never-ending loop of saying, well, my financial situation may have changed now, and maybe now, and now it's different again. And it seems to me that an attorney fee award, unlike, for example, a child support award, right, is an award at one period of time. And I wonder if you could speak to that as to why we should be reassessing this, quite apart from the fact that it seems like this could have been raised before. Why would we reconsider this now?
If there had been a year that passed, that makes sense. There were 7 years that had elapsed in the interim, and that was not on us. Mr. Wolfe took 5 years to get a final judgment and take an appeal from a 2012 order. So the problem is there has been no assessment that we did argue in 2012 when we were briefing after the financial hearing. I wasn't the lawyer, but there was an argument about how both her assets and her income and her expenses were insufficient to pay an attorney fee award. And
this is a question. Did your client not have an ability to move the court for a final order? Was that solely on Mr. Wolfe?
Yeah, why would she have moved for a final order? She had an attorney fee award entered against her that Mr. Wolfe was making no steps to enforce, taking no steps to enforce. So she did not move for a final judgment. In fact, she was under the impression that the attorney fee matter had gone away, because when this court reversed back in 2014, Ms. KHAWAM was under the impression that the settlement agreement that the parties entered into mooted the attorney fee question. And so when Mr.
Right, and so, but when Mr. Wolfe then did go back and move for a judgment, right, and you argued delay, you did not argue ability to pay. You did not argue in 2017 when he finally moved for a judgment, well, wait a second, now my circumstances are different and I don't have, or you know, my inability to pay is more pronounced.
Judge Easterly,
in the 2017 in your opposition to the motion for a final judgment.
So your understanding of the facts is incorrect, and perhaps it's because I've been, I need to tell, in 2012, Ms. KHAWAM's income was $50,000 a year. In 2019, Ms. KHAWAM's income was in the low 100s. So her financial situation, income-wise, was actually better, not worse. So whether you look at 2012 or 2019, you've got a woman who the court knows makes X and has Y expenses. And some of those expenses were actually imposed by the trial court after the financial hearing in 2012. So the court turns around after the financial hearing and imposes child support on her. So there are now more expenses on her than there were at the financial hearing. So there's no...
But this is a case where we're not talking about a party who simply has one stream of income from a job, right? Or at least that was what the trial court seemed to conclude, right?
Well,
and so it's a different situation where she seems to have a job that pays her an amount of money, and then some sort of much more amorphous, undocumented stream of money that she has access to. And so that is why the court, recognizing that she had paid none of her legal fees, said in the end, I think this is a situation where the fees should be paid because this litigation was brought by the father in the best interest of the child. And he has borne all of the fees, and I'm going to split the fees between the two parties. I think that's what's fair and just under the situation. That's how I read what the trial court did in 2012 and reaffirmed in 2019. I don't see that as punitive. It's just a recognition of this is the best interest of the child fee award, and this is how I think it's most equitable to allocate the fees. Both parents should pay 50-50.
I'd like to look at what the trial court says, and maybe we can really reasonably, to a reasonable person, would it sound punitive to say that she was falsely claiming to be unemployed when there was no dispute that she was unemployed? The court said she was strategically and fraudulently claiming bankruptcy when she was actually discharged after a lengthy investigation that was triggered by Judge Kravitz's stating that. going well outside the confines of what was in his four corners, her bankruptcy would not
Ms.
have
Khan,
been.
can I just clarify, are those statements that you're objecting to, were those in the 2012 and I'm not sure what year it was, 2014 order, or the older orders, or are they in the order currently at issue?
They're in both.
And let me just step back for a second, because you said you think it's kind of common sense. Of course, the ability to pay needs to be determined as of the time of the remand proceeding. And it's not clear to me one way or another whether that is commonsensical. And I have two kinds of questions about that. One of them is, do you think that's true of all the factors? So do you think if your client had said, you know, at the time of your 2012 order and your reaffirmance of it in whatever year it was, you thought, based on the information you had before you then, trial judge, that Mr. Wolfe was expending his fees in the best interest of the children. But, you know, a lot has happened since then. And about how Mr. Wolfe is behaving, about how, the right way of understanding your client's conduct, and you want to reopen that question. And you want the trial court to take additional evidence on it that would include additional information about what's happened in the interval, and to rethink that, and maybe to determine that really all along, the fees that Mr. Wolfe was expending were not in the best interest of the child, and in fact, they were frustrating the best interest of the child. Is that something also that common sense says has to be determined at the time of the remand hearing?
No, Your Honor. The other factors that go to the amount are static. They're the quality of the nature of the services performed, the necessity for the services, the results obtained. Those are static. Those are frozen in time, if you will. The party's ability to pay.
Why is whether what a particular fees that were expended? I mean, that issue, subsequent events could tell you more about, right?
I don't think so. I don't know how the quality and the nature of the services would change.
That wasn't the question I was asking about. I was asking about the best interest of the child.
But the best interest of the child is not a factor in an assessment of the amount of fees.
It is true, but it's a prerequisite to there being fees.
No, but
so the amount should be zero. I would think the amount should be zero if your client would have an entitlement to say, well, we need to figure out what the amount of the fees is. If these fees were not expended in the best interest of the child, the amount should be zero. And I can show you now, based on further information, that the best interest of the child did not favor expenditure of these amounts. And so the amount of the fee award should be zero.
So I think what you're saying is, should the first aspect of the necessaries doctrine, whether the court had power to issue an award in the first place, which is what relates to the interest of the child, can be reopened. And I would say no, that would not be reopened, because you affirm the court's assessment of that question, but you reversed on whether the court applied permissible factors. And
fair enough. That may be a good distinction. Let me just ask you the other question I was interested in. Is it your position that the sole issue always is current ability to pay? So if there's a remand, it has to be assessed with current ability to pay. And what I mean by that, for example, imagine that at the time of an original necessaries award, the party who was required to pay had a pretty good ability to pay. And then imagine thereafter, that party had gone on kind of a spendthrift lifestyle and had spent all sorts of money in irresponsible ways. Worst case scenario, an intentional effort to prevent enforcement of the necessaries award. And then there had to be a remand, and the trial court on remand is confronted with the argument, well, the issue is my current ability to pay and I don't have any. Is the issue always the current ability to pay, or is it sometimes no? The relevant question is, at the time I issued my original order, the trial judge might say there was an ability to pay, and that's what I think is more important here.
Well, two things. We don't have that situation. As I've told you, Ms. KHAWAM makes more now than she did then. But the bigger problem is.
Well, but my question is conceptual, though. I agree with you. We don't necessarily have that situation. But I'm trying to figure out the scope of your argument and whether it's just common sense. The issue is always only if you are entering a new order on remand, Judge, the question is current ability to pay. That is the issue. or whether you're saying, no, it's really more complicated than that. The trial judge might have discretion to take into account current ability to pay, but also could consider past ability to pay at the time of the original order and why that's changed. And I'm just trying to figure out how categorical and absolute your view is.
I don't have a categorical view, Judge McLeese. I really think that this court didn't speak to the question. I think reasonable people can differ. My main argument is that it didn't happen with respect to either juncture. It didn't happen in 2012, and it didn't happen in 2019 when the court regurgitated what it had done in 2012. And I want you to look at how it treated her income. All we have is what the trial court did, and it did it.
Ms. Khan?
Yes.
Ms. Khan, may I interrupt you? I've been sort of silent, and I don't want to prolong this discussion because we're going way over time. But I have to say, I find this a little bit confusing, and maybe you can help me with one or two very quick answers to things. If Ms. KHAWAM in 2012 did not make an argument to the judge that you have to consider my ability to pay, or to this court on appeal in 2000, from that 2012 order, that the judge erred here by not considering my ability to pay, and this court then sends it back and basically says, you know, you did everything fine except you missed these two factors. And then she now says, in effect, my ability to pay now is actually better than it was back then. I'm having trouble understanding why we're talking about this, because Ms. KHAWAM certainly doesn't want to go to court now and say, you know, Judge, if you considered my ability to pay, you would have, it's gotten better now, so you would have entered a bigger award against me. She doesn't want to do that. And it's not a basis for entering a smaller award or a different award. So I'm really having trouble following all this. Relatedly, I'm wondering whether on remand, Ms. KHAWAM actually made a proffer to the court, and that is to say a fact-specific detailed proffer of what an inquiry into her current ability to pay would show. So that's why I'm somewhat mystified by this discussion. Can you sort of fairly quickly, because I want to give Ms. Wilkoff a chance to be heard while the sun is still up today, a chance to be heard. So if you could respond briefly to my mystification, I'd appreciate it.
Well, one assumption is incorrect. She did argue in 2012 that her income was thus and such, and that her expenses were, she talked about the substantial sum she owed attorneys, that she was underwater on her condo, that she had a six-figure student loan debt, upcoming child support obligations, and that was in her post-trial brief of March 22, 2012. It's not in the joint appendix.
I see.
But
Okay. It's not, okay, I accept that. But on appeal from that, the judge said, well, I'm not taking those things into consideration in effect. And on appeal from that, it sounds like Ms. KHAWAM did not say that was an error on the part of the judge. Or at least this court did not find it to be an error. So so if her situation now may be different, my mystification questions sort of remain, basically. Help me out. Why, I mean, if you're telling me her situation is improved somewhat, why does she want to bring that to the judge's attention?
because
This may help just add to the amount.
because Judge Glickman, she can't pay this award. It was too high.
That was true back in 2012.
Exactly. But what the court did when it went back, whether or not you look at 2012 or 2019, the court did not make a finding. It didn't make a finding then, and it didn't make a finding now. And if you look at what it did do and redo in 2019, it was all punitive. And that's the problem here.
I don't know. I don't think that's quite right. It seems to me the judge said back then, you know, I hear what you're saying, but somehow, whenever you need money, it magically appears. And I'm taking that into account. And our case law does not really support the notion that the judge is limited to considering net income in a situation like this. So to me, it looks like a situation where this is an argument you could have made on appeal in the appeal of the 2012 decision. but for whatever reason, this argument was not made. And I don't think I think it's a little too late to bring it up now, especially if the nature of the argument is their situation has changed for the better, since it can't possibly be helpful. That change can't possibly be helpful. And you would just be asking the judge to redo the things that the judge already did in 2012. And as I say, I'm also wondering whether you made a factual proffer on remand from this court in detail of the ways in which her economic situation had changed for the better.
Well, her affidavit that was submitted on remand goes through the expenses that she was facing. The other thing is, when you look at the way the court talked about Ms. KHAWAM with, again, 2012 and 2019 with respect to her ability to pay, what we have is not just a failure to consider her income and expenses, it's an explicit disavowal of an interest in considering her income and expenses because, again, everything she says should be dismissed. You've never said that the income of her sibling and the income of the people who were prepared to give or loan her money guides an attorney fee or child support determination. I mean, think about this. This is a woman.
Well, think about this. Suppose the judge says, you know, you people have been litigating this really hard. And Ms. KHAWAM, you've spent, conservative estimate, a couple of $1 million in attorneys. I don't know the numbers, so I'm making this up. But, you know, I have an idea. A couple of $1 million in attorney's fees. Somehow you have the ability to do that. And I think there's a necessaries argument here that you've got to bear a fair share of the attorney fees spent on behalf of the child. And, you know, I'm not giving you everything Mr. Wolfe has asked, but $350,000 seems like a fair share to me. The notion that she can say, well, what you say is true, but, you know, my income actually isn't really high enough for me to make that, and I have all these other expenses. It seems fair for the judge to say that didn't stop you from somehow finding $2 million for your own attorney's fees. Now, I understand my numbers are, you know, there for illustrative purposes only, but I just sort of remain mystified that this argument is essentially being raised before us now to try to redo something that we thought was done, except for one little glitch back in 2012. And when we send it back, the judge looks us in the eye and says, all right, I'm re-looking at what I did and what I was thinking. And, you know, it really, the bad faith aspect of this and the burdensomeness aspect of this really didn't really have a was not really a big factor in my coming to the conclusion about that $350,000 number. It's hard for us to look, to see what the judge, you know, it's hard for us to see that we shouldn't take the judge's statement about that as one on good faith. But I don't want to cut you off and say one more thing, and then I think it's only fair to give Ms. Wilkoff a chance to speak, and we'll hear a few minutes from you.
Well,
what I just said.
What I would say is that you can take the judge at good faith, but you can only believe one of his statements. They cannot both be true. What he said in 2012 and what he said in 2019. One is these factors weighed heavily in the amount I'm issuing. And now he's saying these factors played virtually no difference. They cannot.
It's sort of like a case of overdetermination.
Sorry, Judge Glickman.
It's sort of like he's saying that my ruling was overdetermined in a sense. Well, let us hear from Ms. Wilkoff, and then we'll give you a few minutes in rebuttal. Counsel.
Thank you, Your Honor. If it please the court, my name is Sandra Wilkoff, and I represent appellee Grayson WOLFE. I have represented him before this court twice before on the issue of attorney's fees. We are here today following a very narrow and specific remand by this court in 2019, which remand was considered by Judge Kravitz, who heard the case in 2011, 12, 13, 14, 15, and through until the beginning of 2016. The remand was specific. It was after determining, this court determined that the trial court had extensively discussed the permissible factors in determining an attorney's fees award. He may have also considered an impermissible factor.
Counsel, can I stop you on the word may?
Yes, Your Honor.
Is that in our opinion?
Yeah, well, it was in part of it. It was a question of, it was quite possible that the trial court's decision to fix the award at $350 was affected by the trial court's consideration.
Right, but that at earlier places where we described the nature of the error that we perceived, we weren't equivocal in the way that you were, or that the trial judge on remand was, where I thought we said the trial court explicitly, I don't have the order right in front of the opinion right in front of me, but I thought we said the trial court explicitly, relied upon or based its decision on impermissible factors. Is that correct, or do you dispute? Are you suggesting that that our opinion was unclear about whether the trial court had, in fact, relied upon impermissible factors in making its ruling?
I understand the question, Your Honor, and I think that it is fair to say at the beginning part of your order, you were explicit that he had. In the second part of the order, it was in considering whether it was harmless error. You said it was not harmless error because it was quite possible that the impermissible factor played a role in calculating the actual award.
Right,
So,
and the way I would read those two, rather than being sort of inconsistent, is that the first set of statements is the judge gave explicit reasons for the conclusion, and these impermissible factors were among them. So the judge, it's not disputed. The judge, we were concluding that it was explicit. The judge relied on such factors. And then on the harmlessness, the issue is more the one that is now being disputed, which is, did that actually affect the amount? So again, I can say, I have 7 reasons for what I'm doing, and then I do a thing in a particular amount. And the issue still remains, well, would I have reached the same amount or a different amount if you took away some of my explicit reasons? So in any event, do you think our opinion was internally ambiguous and equivocal about whether the trial judge explicitly relied on impermissible factors? Or do you acknowledge that it was explicit that the judge had relied on, and that that it was consistent and explicit that the judge had in fact relied on impermissible factors?
I think your opinion was clear, and you spoke about explicitly relied on. I argued back then, and I still believe, though I understand your opinion is what it is, that the 2012 language that the trial court used was terrible drafting. I think because in order to determine whether to issue an award at all under the necessaries exception, you have to, you may look at the bad faith, the oppressiveness, and the burdensomeness. Unless a trial court then writes a second opinion and divides them entirely, some of that might bleed into the factors for determining how much. And I think that's what happened here. He didn't make a clear enough distinction between what he was relying on in determining that the award was appropriate in the first place, step 1, and how much that award should be, step 2. But I think he made it very clear on remand that he did know what he was doing, and that he did exclude the considerations for Ms. KHAWAM's bad faith and the burden it imposed on Mr. WOLFE when he came up with the $350,000 award. He said explicitly that one of the reasons that the bad faith came into play is because that was one of the grounds for the request for attorney's fees. And he had to discuss that to put it aside into that part of the order that reserved for a later date Mr. WOLFE's ability to come back and seek more. And he said that had he meant to include Ms. KHAWAM's bad faith in the attorney's fees award under the necessaries exception, he certainly wouldn't have discounted it quite so much from what Mr. Wolfe asked for. He discounted it by 50%. I think he was pretty clear in his calculation or his reconsideration of the factors that went into the 2012 award, and that those supported the award he made. I was at first very surprised by his abundance of caution deduction to the award, because I thought that he made it pretty clear that it hadn't been calculated in at all. But just as the trial court's original award is entirely within his discretion to make, a deduction for what he concluded was, if anything, a de minimis impact that the consideration of that impermissible factor had on his award. It was with his discretion to do that as well.
Can I ask you about the second issue and whether the trial court could have or was required to take updated information about ability to pay? And the trial court said, this is a paraphrase, so feel free to resist the accuracy of it as a paraphrase, but the trial court seemed to say, in explaining why the trial court was not going to take updated information about ability to pay, that taking ability to pay, current ability to pay into account would be contrary to the spirit of our remand order in the second KHAWAM opinion, and that our opinion in that case logically, most logically focused on ability to pay back in 2012. And I guess I'm wondering what it is you think about our opinion in KHAWAM 2 that would support either of those two thoughts. Like, why do you think, what about it do you think logically points you to ability to pay back in 2012, or that has a spirit that would be frustrated by focusing on more recent circumstances rather than 2012?
Well, I think number one, I think there should be a presumption that when you remand an order issued in 2012, that the reconsideration is made based on the record that supports that order. And the
I guess
record that
why do you
supported
say that? It seems to me that that's very much context dependent. When we're talking, for example, in family law cases about the best interest of a child, and we're remanding within an adoption case or something like that, when we remand, we often expressly say, the trial court on remand shall take into account, any change in circumstances. So there are times when we dictate the taking into account of current circumstances. There are times when we don't say anything about it. There are times when it's pretty clear no one would think we should go, the trial judge should go back and rethink. I mean, if a trial court in a bench trial made some findings in connection with its verdict, and one of them didn't have, wasn't supported by the evidence, I think most people would imagine if we sent it back to the trial court to reconsider its verdict and to determine it based only on facts that are supported by the record, I don't think anyone would think the trial record should be reopened. So it seems like it's very much a matter of context when updated information is required, when it's in the discretion of the trial court, and when really it wouldn't be appropriate.
Well, I think in a case like this, where you have an award that was entered in 2012 and was ignored by the person who was ordered to pay $350,000 no later than August 31st, 2012, and didn't pay a penny until she was forced to after the judgment was entered in 2017 by virtue of garnishing her income and seizing a very small bank account. If she thinks she would benefit by reopening the record, or if anyone would benefit by reopening the record on what the original award was based on, it seems that the extension of that argument is anybody could change their financial situation by digging their heels in and refusing to obey an order.
Well, let me ask you how far you take your view. So, I mean, imagine in a case where it's really hotly contested at the time of an original necessaries award, whether the party who is required to pay under the award has an ability to pay, and that's big a dispute, and there are legal issues, and the court ends up remanding and sending it back, and right after the remand and before the trial court takes the issue up, the party who was required to pay, wins the lottery and now has $100 million and could easily pay. You're saying irrelevant, doesn't matter. The real issue was whether the person had the ability to pay at the time of the original award. Is that right? And not only that, it's not like the trial court has discretion about whether to take that into account or not. In your view, as I understand it, and correct me if I'm wrong, the trial court would be required to ignore that and focus solely on the record as it existed at the time of the original order. Am I understanding your position correctly?
I imagine that what you're talking about, Your Honor, would be more in the nature of a motion to modify the trial court's order rather than an appeal of the order. There was no motion to modify.
My question is, if the order has been vacated and the matter has been remanded and the trial court needs to issue a new order, and the question is, what is the temporal focus about ability to pay when the trial court is issuing that new order?
Well, I haven't found any case law that suggests that on remand, the trial court should reopen for a new evaluation of her ability.
Have you found any case law that says the trial court can't?
No, Your Honor. I found no case law on any of it. The case law that Ms. Khan seems to be referring to with regard to net income, and that the judge didn't find in 2012 what Ms. KHAWAM's net income was. There's one case that refers to net income. That was an alimony case where net income is relevant. In the attorney's fees cases, it is just one factor among many that are considered by the trial court.
I guess, are you disputing that I'm not an accountant, I don't have a CPA, but are you disputing that net income in a general sense isn't one of the factors that a court could be considered, right? I mean, it's sort of the party's financial health. We're not just looking at kind of how much money they make, but kind of how much money they owe, how much, what their expenses are. We're supposed to be looking at the total picture of a party's financial health.
Right.
Right.
And, yes.
So net income in that kind of general sense, and maybe that's not, true net income as an accountant would define it.
I think the income of the party and the expenses of the party and the assets of the party, all of these things are relevant to a calculation of ability to pay, which is one of many factors to consider. There is no specific requirement to find.
It sounds like you're concerned that maybe the court didn't consider that in 2012.
The problem in 2012.
I read the order in 2012 as the court trying to consider net income in the way that I have described it in sort of, perhaps colloquial understanding, is that the court is trying to assess net income. It's just that the court doesn't quite know what her income is and what her liabilities are because she hasn't told the court, right?
Well,
I mean,
on
page 13 of the 2012 order, the court is describing, well, first she is employed and has a $300,000 job, but by the time of the divorce trial, she is unemployed. She files for bankruptcy. She says she's got $1 million in debt, but then she says in the divorce trial that she has no obligation to repay that debt. The court can't find its feet with respect to what her financial health is because it's still kind of shrouded in mystery.
That's correct, Your Honor. With the substantial evidence of the financial evidence that was presented, the trial court made the ultimate determination that the relative ability of the parties to pay was a factor that he considered and informed the $350,000 award.
I seem to
Ms.
recall,
Wilhoff, sorry.
I'm sorry, I just have one question. In the 2012 argument, because we have this case, we have all of the record materials in this case. It's in the argument in the divorce case in 2012, I believe you said that Ms. KHAWAM hadn't even submitted a financial statement. And I'm wondering, did you ever move to compel her to supply a detailed financial statement to the trial court?
I don't think I did. I don't think I did. And the financial statement we did file pretrial statements, which had financial information attached to it, but not specifically a financial statement. I don't believe so.
Ms. Wilhoff, I guess I want to ask you the question that I also asked Ms. Khan. In the proceedings on remand, did Ms. KHAWAM ever proffer to Judge Kravitz in any sort of substantial way that her financial ability to pay the fee award had materially changed and deteriorated from what it was, whatever it was, in 2012?
Your Honor, the only thing she submitted in support of her current financial situation was an affidavit in which she explained to the court that she was making a lot of money and that she had paid $279 or something $1,000 in 2019 from January to October for attorney's fees, not to Mr. Wolfe. And that her financial situation as far as money coming in and money going out supported a finding that she was doing quite well financially.
See, the reason I ask is my reaction is this. We have said, for example, Stedman, that there are 4 factors that the judge should be considering in deciding the financial award under the necessaries doctrine, and one of them is the financial ability of the spouse being ordered to pay. So I can understand if on remand, and that was considered in 2012. Ms. Khan may not like the way it was considered, but that was considered in 2012, and we in our appeal said nothing negative about the judge's consideration of that factor. And on remand, I think if a proffer had been made that there's been a material change, and it's a material change that would affect how much you award me to pay in a negative way, then perhaps Judge Kravitz should have considered it. But it doesn't sound like there was any suggestion of that. It sounds like if anything, there was a suggestion on remand that things have gotten somewhat better in terms of financial ability to pay here, but the judge isn't going to increase the award. So to me, that's the end of the inquiry. Do you think I have an accurate picture when in that summary?
I think you do, but I again, there is no precedent that would allow her to recalculate. And I apologize. One of the questions I believe to Ms. Khan was, can you keep changing? If you fail to pay the attorney's fees award every year, can you come back and say, well, my until it's paid, my income has changed, my income has changed, my income has changed. Let's keep changing the attorney's fees award to match what is happening right now. And I think that's why Judge Kravitz went back to the substantial record that supported his findings in 2012.
Ms. Welker, can I ask you about your answer to an aspect of your answer to Judge Glickman's question? When you're describing Ms. KHAWAM's affidavits submitted in connection with the remand proceedings that are, currently back up in front of us. You were saying, it sounds like her financial position, that her financial position is good, but I'm just looking at the supplemental appendix, and at least one part of it, for example, is, this is supplemental appendix 169. She says, my income this year will be in the negative. My firm has paid wages, so they're going to give me $100,000, but this firm has suffered losses, and my income this year will be negative. And then she also says, my friends used to be more willing to lend me money, and now they are less so. So I guess I'm wondering whether your summary of the gist of her affidavit is complete or fair, or whether it's somewhat one-sided.
Well, Your Honor, Ms. KHAWAM has said those things from beginning to end. Her credibility is, especially and including with regard to her financial situation.
Well, that's a different point.
Suspect.
I mean, that may
so
be
for
true.
her to say that I'm not going to make money, who believes?
I mean, that may be true, but I don't think Judge Glickman's question was about whether you believed or whether a fact finder should believe what was in her affidavit. I thought it was a question of what she presented to the court in support of her claim that she wanted to have a hearing that would be focused on the current situation. So the credibility, your views as to the credibility of that seem to be quite a different topic from the question of what it was that the court was presented with.
Perhaps. The court has any more questions? I think my brief pretty much boils down the argument of appellee. We ask that the court affirm the order for $325,000 on remand plus post-judgment interest back to 2017 at the statutory rate.
Good, thank you, counsel. Ms. Khan, we'll give you a few minutes in rebuttal.
Ms. Khan, you're
Muted.
That would help. Sorry about that. Let me start where Judge McLeese and Ms. Wilkoff left off, which is about Ms. KHAWAM's affidavit. So at SJA 168 through 171, not only does she talk about her earnings, but she talks about her expenses. And those are important. She was footing the bill, the entire bill for a guardian ad litem that the court had appointed. She was paying for the child psychotherapy. She was paying child support. Her wages were being garnished.
Right, and I guess this is what's so tricky, right? Because these are all things in the future, right? And so she's looking at the 2012 award and saying, based on all these things that have now happened, you should reduce my 2012 award. And I'm trying to figure out why that makes sense.
Well, it makes sense because if you're talking about an inability to pay, and you're talking about a regime where people cannot be put into a lifetime of debt that they have no way of sustaining. That's the world we're in. We're talking about an attorney fee award. The law says can be imposed only with respect to ability to pay. And with respect to your question, Judge Easterly, you said you read the 2012 and then regurgitation of the 2012 award as an attempt to assess net income. I don't see how you can possibly say that. The discussion doesn't even mention her income. It doesn't mention her expenses.
I think the court assumes that she doesn't have any income, right?
No, I mean, no. Look at JA 429. It's the income worksheet. It says her income. It was $50,000. That's if you look at the child support discussion of the same order. I'm sorry, not the attorney fee order, but the child support discussion of the financial order, which issued 2 months before the attorney fee order. I can give you the site, but it's in the JA. He has a garnish, he has a child support calculation based on the financial evidence at the 2012 trial. And it says her income was $50K. So think about that. You make $50,000. You pay taxes on that, right? Now you pay child support of $1,000 or so a month. What are you left? Is it really realistic?
Again, Ms. Khan, this is a case where your client seemed to have an alternate stream of income
But
that paid for, substantial hundreds and hundreds and hundreds of thousands of dollars in legal fees in this case, among other things. So let's assume, just for the sake of argument, that we disagree with you as far as any attack on the 2012 assessment of your client's ability to pay, okay? But the question is whether the court should have reconsidered her ability to pay in 2019 post-remand at post-KHAWAM 2. And I guess my question is your argument that the court should start from scratch and just reassess de novo ability to pay? Or is the inquiry whether whether circumstances have materially changed from 2012 such that the award should be reduced?
I didn't take a position on that.
I'm asking you to take a position now.
Yeah, I think that you vacated the award. So I think it makes much more sense to me to look at what the person can pay now. There's no more award in place. So you're
not a comparative analysis, just start from scratch.
In this case, there was a child support motion to modify pending. It wasn't starting from scratch. There was evidence.
No, I'm not start from scratch in that there aren't other things going on in the case. Just with respect to the attorney fee award, don't use that as your foundation and say, does this need to be modified up or down? Erase it and start anew in calculating how much should be awarded in fees.
Well, you had already said it needed to be modified, right? So got a vacature of this award. Now you're looking at this and you're wondering, okay, should I look at 7-year-old evidence to make an assessment? Does that make sense?
And I think I'm not quite understanding, and maybe I'm not expressing my question. Assuming the 2012 award properly considered ability to pay, and that award said $350,000 in fees should be paid by your client. On remand post-KHAWAM 2, are you saying that the trial judge should have looked at your client's financial health and said, this award, $350,000, should be modified up or down? Or the trial court should have started afresh without any number in mind and calculated what should have been owed in fees from 2012?
I think the court should have followed your instructions.
We didn't instruct. I'm asking you what you think the trial court should have done. Do you understand my question?
I'm not really. Let me tell you, I think
I'm really just saying, should the trial court on remand have started with a $350,000 figure and modified that up or down? Or should the court have started without any figure in mind in 2019 post remand and calculated the figure anew? And which is it, A or B?
B.
Thank you.
It's very clear that you remanded for a reconsideration using permissible factors of the amount of the award. The earlier award was tainted, explicitly tainted in an important way. The court used the word, those factors weighed heavily. So I think the court needed to start over. It needed to say, all right, I've got a set of permissible factors and I've got to look at them. And I think the evidence with respect to most of them was static, as I said earlier, but the inability to pay, I don't think is static because you don't any longer have an award in place. And now you've got to figure out what can the client pay? I also want to submit that I don't think it's your assumption that you're saying, take us for granted that the court properly concluded that she could pay. I think there's a real leap of credibility on this. not a person who makes 50K. With respect to her siblings being willing to give her money, this was a woman whose child was, she was stripped of a child who was 3 years old, and she had to beg, borrow, and plead people to help her pay legal bills to try to keep a relationship with the child, which has now been completely and utterly wrecked. She has not seen this child for 1.5 years right now. And so of course she was going to beg, borrow, and plead. And of course people who loved her were going to be willing to give her money to do it. But they're not willing to pay Mr. Wolfe's attorney's fees. So where does that leave her? It leaves her with a judge who has basically said, I don't care about your income. I think you've been bad enough, and I don't believe anything you say. And so I'm not really going to assess whether you can pay. I'm just going to assume you can. And that's the problem, is that you can't issue an attorney fee award, even if you think you've got a lousy payor, even if you think they're a big liar. You said in Muma v. Muma, you still got to make an assessment. And honestly, it doesn't matter whether it's an assessment of 2012 or 2019. It was never made here.
Okay. Counsel, thank you both very much. We have the case, and it is now submitted. The two of you may log off.
Thank you.
This court